Happy Friday Night Live. It is September 17th. We have a sleeping Ponard. My neck has decided that it is going to be, old and stuff tonight. So if you see me moving awkwardly, yep, sure is happening. It's so good to be with you all. It's so good to see you all. I've got some watermelon kombucha this evening. That's where I'm at. We have a lot to cover. We have a very packed weekly roundup. Then we have Trisha Paytas getting sued for defamation. Then we have the H3 Triller, all of it. I can't say it's a mess because it's not H3's mess. Ethan Klein's lawyers have been doing a fantastic job. The lawyers for Triller are not my favorite, and everything they filed has been messy. We're going to be very, very busy tonight. We are going to be we are going to be moving. We are going to be moving this evening. There will be some topics that are a little difficult. I will make sure to let you know when they're coming up. Replay crew, we love you. Go ahead and, hit the timestamps when you come in on the replay. You will see whatever topics are a little sensitive. I will make sure to give you guys the heads up so it's not surprisingly triggering for anybody. And I will do my best to talk about everything with respect, stay monetized, and have fun where it's appropriate. It's time to just have a evening. I see Nicole Z asking what brand this is. I think Synergy. And tonight I'm rocking my Dave Matthews Band t-shirt. I was not with all of you last Friday because I was seeing Dave Matthews live. I have said regularly it will not feel like the pandemic is lifted a little until I am back with my favorite band. And that happened last week. And, tonight my heart is with all of you at SPAC. I know you're not watching this if you're at SPAC, so have the most fun ever. And it's just time to go. It is time to ride. It's time to ride. Let's go.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
Yes, y'all. It's so good to see you coming in. We had over 1,000 votes from this. And you guys, 43% of you want to hear about Gabbie Petitio first, then Westbrook updates, then lawyer John Pierce, then Theranos. It is so good to see you. All right. I don't think my text went out to the text crew. So text crew, I'm sending out another one right now. I actually really like 19 Crimes. It's so good to see everybody coming in. Thank you for the super stickers. Hello, Canada. Hello, Australia. Y'all are the best. So thank you for being here. As we get into the Gabbie Petitio story, it is look, for everybody who likes true crime, I'm sure you are riveted and fascinated. True crime, especially as it is unfolding in real time, is always a little difficult for me just based on my own previous work and life experiences. I'm just going to be catching up onto what's going on with this, why legally some of the things are happening that are happening. Her fiance's home is being searched. I'm going to give a little bit of a background on that case. This is still an open investigation with a missing woman who is also a social media influencer. So we are going to talk about it. And like with everything, I always appreciate you guys being respectful of what we talk about and the people we talk about. We are going to talk about some difficult personalities like we do every single week. And the thing that I appreciate the most about you as law nerds and the community that we've created is that we can do that even when feelings are high, without name calling, without wishing ill or harm on people. And in a, I'm very frustrated and I have feelings about this, but those feelings are my own and I am not going to lash them out at anyone else. So I appreciate that. We always have a no name calling policy in the chat, and that goes for everyone, no matter whether we like them or we don't. Even when I say that I don't love Triller's lawyers, I would still stand by no name calling in the chat, even though I might agree with the name calling. But that we can't have a policy that shifts all the time. That's not consistent. So we have a consistent no name calling policy, and no all caps policy. Nightbot is very sassy about it, and that's for me. It just makes it a lot easier for me to moderate and still be able to see your questions, because I don't want to get to a point on this channel where I can't answer questions about the legal things that we all want to talk about, because if I can't see stuff, I can't answer it. So that's what it is. I am sending this out. Text crew, if you're in the text crew, I am sorry it did not go out. It is out now. If you're not in the text crew, textemily.com if you're in North America, and you can join. I saw a number of super chats, so I'm going to do those and then get into this story and get into the weekly roundup. Peggy, thank you so much. Jennifer H, thank you. Hello from Britain. Emily, thank you for getting me through a root canal today. Yay. My dentist now knows more about Brittany's conservatorship than he ever wanted to, sending you money for coffee and to say thank you. Well, you're welcome. I'm happy to get you through dental work. It causes me stress too. I absolutely get it. Hello, Matthew. Hey, Emily, I'm here to ride. I just got done bleaching my hair and washing it. Queen Levine would love and appreciate me. I'm not drinking anything right now. I'm about to go grab it. After I send this, I'll be joining Orange Hairdom tomorrow. Can't wait to see the orange hair, Matthew. And I love that you were able to send the orange super chat. That it just feels like it all works. So let us go and get into this story. So this is a story about a missing woman in a domestic partnership, and we are just going to talk about the facts as we know them and a little bit about the law that governs those facts. I know people have a lot of questions about this case, so we're going to do the best we can to cover this with compassion on all sides. All right, let's do it. Weekly roundup story number one is, Gabbie Petitio. She is a missing woman with an open investigation. Police are still investigating her disappearance. She was last seen with her fiance. They were on a cross-country trip in a renovated van. It's my understanding that it was her van, but they were engaged, and that before they left on this trip, she was living with her fiance's family in Florida, which is where he is now. Their house, the family home, his parents' home in Florida, is currently being searched this evening, according to the live news reports that are outside of the home, watching police kind of go in and out and search the home, which means they have obtained a search warrant for the home, not just for a vehicle, and they were searching vehicles and the home, which is a step in the right direction with any investigation. He is naturally a person of interest in this case because he is the last one that was seen with her. He has since returning to Florida a week before it was realized that she was missing, because they were on a cross-country road trip and they were in Utah in like the Arches area and then on to Yosemite. And the news articles governing it kind of has a timeline of where they were going, in that he returned to Florida a week before she was reported missing. With adults, sometimes it's not always easy to know if they're missing. I assume that his immediate family was aware when he came home and the van came home and she didn't, that she was missing, but it was her family that reported her missing after he had been back for a week. Her family has been pleading to the media and everyone else for help, because the fiance got a lawyer and has not said a word about it, and by reports in the news media is not cooperating with investigators, which, though frustrating, infuriating, morality and legality are two different things. We talk about that a lot here. Morally, all of us are like, seriously though, but WTF, but seriously though. But your fiance's missing. Seriously. Legality wise, his defense attorney is like, what you're going to do right now is shut the fuck up. And you're not going to say anything to anyone about anything. And he's not obligated to, can't be forced to. Even if he's arrested in connection with something, still can't be forced to. And they probably just don't have enough to arrest him on anything, because he remains a person of interest, not a suspect. They would love to talk to him. He would love to not talk to them. And that's what's going on with the investigation. with regard to missing persons investigations like this, the law enforcement will be very busy. This is multi-jurisdictional because one of the people of interest is in Florida. The potential location that she went missing is in Utah, but could be in Wyoming, depending on where you are on those borders. So you've got multiple jurisdictions working this. For an adult, it is difficult to get cell phone records and get into their cell phone records and things without them being missing for 10 days or more, because you have to get a court order to do that. You know, as someone over the age of 18, your parents can't just be like, get into their cell phone records, find out where they are, because people do have the right, though in this case it seems like she's clearly missing, people do have the right to not always keep everybody informed of their whereabouts. It's always good to talk about those things with friends and family and be like, hey, I'm going to be off the grid for 3 days. I will reach back out to you on this day or that day, and keep open communication with people and let people know when you'll be checking in. Because then at least you can say, she was supposed to check in on this day, she didn't. And then you have a place to start if you need to get into cell phone records, use social media accounts, and start tracing where people are. Those things take search warrants to do, and there has to be enough probable cause that they're missing to invade their privacy, because you have to have a belief that there is something wrong for somebody to even write a search warrant on. So it is difficult. Missing persons that are over the age of 18, you know, if this was a 17-year-old, it would be much faster to be able to get into their cell phones because they don't have the same expectation and privacy. So this is something that is going to be tremendously difficult for her parents. I'm sure the media attention is a double-edged sword because, one, they don't want their daughter, sister, loved one to be known as a missing person, but they also want everyone's eyes on it because the more eyes you have, the better, which is why I chose to talk about it. I don't often talk about open cases in true crime. But the circumstances are suspicious. And especially when you have somebody who's not talking at all, and you have, you know, 2 people go out in a van and 1 person in a van comes back, it's going to raise a lot of questions and an investigation. So I will be on my own keeping an eye on this. We will talk about it again if stuff comes up, but legally there is not much that can be done yet until it's proven that there is something that potentially an individual can be charged with. There was also in the area, there was another couple found killed, and they are investigating those angles as well. But again, frustrating as it is, they can't force her fiance or his family to cooperate with investigators. And that is your Fifth Amendment right against self-incrimination. We've talked about it a lot in the last couple of videos, but you can't be made to say anything. And you've got to remember when we talk about criminal law, that criminal law is set up so that no innocent person is convicted, even if that means that some guilty people walk free. There are quite a lot of constitutional rights protecting against wrongful conviction. And I know there will be some of you going, but it doesn't feel that way. I know. And it's hard and it's frustrating. So that is what is going on with that. We have a few super chats I want to get to, and we will. And then we will start getting into easier things. So Matthew, watching you on the iPad Pro, I love the screen on my iPad Pro. Thank you. You guys, it's like open case true crime is hard for me to talk about. And some of you will see that it just is. It is very hard. Bence, I know this is off topic. Have you seen the 2007 Britney rehearsal video with the ponytail? I have not, but I will look for it. Rich, looks good to see you. So much drama there is. We're going to get into all the drama soon. Kelly was asking, why did they wait a week? I don't think her family knew. She was supposed to be camping and in and out of areas with cell phone coverage. I don't think they realized she was missing for a week. And that is not, unfortunately, uncommon, which is why the best I can say is that if you are traveling, if you are out and about, just have somebody that you're checking in with and let them know. I don't know if this is something that everybody thinks of, but when I travel by myself, this is something I always think of. Like, I'm on this flight, I'm landing here, I'm going to the hotel here. I am constantly letting people know when I will be checking in so that you know when you expect to hear from me. And it's just, it's very sad. This is horrendous for her family and friends. It's gut-wrenching for the rest of us to watch. And just, if you are watching this unfold, there are people behind these stories that are in a tremendous amount of pain and fear and stress, and they are waiting to hear one way or the other. Law and subscribe. I did not watch Observe's video yet. I was having issues with my internet earlier today, but I will be watching Observe's video on the police cam footage later. You know that I think Logan's videos are tremendous, so I will be watching that later. I tend to, if I'm going to be covering something, I tend to not, because I was trying to finish up into the other stories today. We have some tough ones today. So Elle said I have an if I go missing folder that I tell a trust and Persian where is in case people can't find me. Has all the important login password info. And password managers can do that too. I have password managers I work with on this show, and you can actually give an emergency contact so they can get into your stuff and try to start getting into your phone, which makes it easier to track people. So it just hurts me. Little Miss Stamper, can they not arrest him for auto theft at least? They don't know that it's a theft because they don't have her saying he took my car. So they are in a relationship. They are engaged. It's not unusual for someone in a relationship to have your vehicle. So no, I don't think they have enough to know that there's an auto theft, and they don't want to mess up their investigation. Investigations are better done slowly. And we see this when we talk about the Josh Duggar case. It took like a year to do forensics and stuff. It is it's really, really tough, but they have to cross all the I's, dot all the T's, get all the search warrants, and do the stuff. So arresting him on grand theft, and then how do they prove it? He through his lawyer will say prove that he didn't have permission to have it. And then they can't prove that he took it. So anyway, that is that. We are going to move on. We have got other things, so we will be getting into them. Piss and Vinegar said they are at the parents' house. Cops are taking brown bags out of the house. Yep. If they have a search warrant, they're going to get all the things, and the investigation will continue on. And generally, once you get to the search warrant part, things start to move pretty quickly. And no, they are at the fiance's house, not Gabbie's parents' house. The gift heart, absolutely. Missing person cases are very, very difficult. And generally, once people have been missing for over a week, it's very, very, very difficult. As a retired flight attendant, always have a buddy to check in with and an itinerary to follow. Also, iPhone has an emergency contact and health feature. It does, which is a great thing to do. I was asked, where did I hear about the search warrant? Well, the only way they're in the house taking things out is because they have a search warrant. They can't just, this is the husband, the fiance, and the family have not been cooperating with investigation. So there's no way, if the police knocked on the door and were like, hey, can we come in and take some shit, that they're going to let it. That all would have to be subject to search warrant. And it's on the local news, and that is being shared on Twitter as well if you want to watch that live footage. So yeah, we have other things. We have an order that we're going in for the weekly roundup. So next is going to be Swanson and Westbrook updates on the roundup. It swooped on time because I'm not on my iPad. Swanson, Westbrook, what? Here's the thing. The Nevada case is moving along. The Westbrooks got a preliminary injunction to force Swanson to turn over items to the corporation. Then there were more motions. There were motions to compel cooperation with the injunction. Those were just heard this week, but there isn't a ruling up on the court's website, and I did not attend those by court call because it's been a busy week for me too. So I imagine they were talking about what evidence needs to be turned over and what doesn't, because we've already seen the back and forth that's going on between the Westbrooks and Swanson in the Nevada case. There's also a motion to dismiss pending in the Nevada case. But y'all, we're finally here. Almost a year later, next week is the motion for form nonconvenience and the motion to dismiss in the LA case. So to see if the LA case moves to Nevada, we talked about these motions ages ago. And all of you were like, how is the next court date in the Swanson case in November 2021? And now it's November 2021. Can you believe it? So next week, there will be a court hearing on the form nonconvenience motion to try to move the LA case out to Nevada, saying that the corporation in LA is not an active corporation and it's not enough for jurisdiction in LA and California. So it will be yeeted, I think, to Nevada. Could be wrong. That's what I think will happen. So there were just a bunch of replies filed to Swanson's opposition. I will go through that with the ruling, and we'll just kind of go through what those motions were. We have not had time. We have not had time to go through it, but I can't believe that we are finally here with the motion for form nonconvenience finally being heard. It's just, what? I mean, when we started talking about this case, I mean, it probably hasn't been a full year because we started talking about this case in October. But then by the time these motions got filed, they were filed in like what, November or December. And all of us were like, oh my God, oh my God, oh my God, I can't believe it's September. Because it seemed like so far we had the Washington case going with Tati and KJ. And then we had this business partner case that just stopped. So yeah, it's here. It's here. It's been, almost a year. But yes. So September 21, 2021, we will finally, hopefully soon, get a ruling on that form nonconvenience. Though we do know that we might have to wait if the court takes it under submission. So that'll be interesting. So that will be something I will be checking back in on next week, and hoping that the minute order from the motion to compel is up on the Nevada court's website next week. So we're just going to keep checking in with this case like every live, because so much keeps happening. And there's the 3, nothing's going on in the Washington case. So, yep. So that was it. Quick Westbrook update. We need to talk about missing lawyer John Pierce. This guy. If you guys listened to the Emily show this week, it was a part 1. We have a part 2 coming on it. John Pierce went missing. The U.S. government filed motions. He's representing a bunch of defendants in the January 6th riots, insurgency cases. Some of those cases are definitely having some issues, but he's representing like 17 of those defendants, which is absolutely wild. So in that, he disappeared and the government didn't know where he was. The associate from his law firm that was appearing in courts, not a licensed attorney, has 2 criminal cases pending, and kept saying different stuff to different courts. Well, John Pierce not only appeared in a letter that he submitted to the courts that we are going to go over real quick, but he also got from LA to DC and appeared in person at the end of this week. So Wednesday or Thursday, and actually showed up in person in court. So that seems like a lot if you're in the hospital for 12 days, then to hop on a cross-country flight. All of it seems strange to me. Like all of it seems strange. So we're going to go ahead and pull that up. Of course, my share screen is ready. Because why wouldn't it be ready? We're professionals here, people. Of course it's ready. Of course it is. All right, let's pull up this letter from Pierce Bainbridge. And the address on here is the address that they have I think this is the one with a lawsuit over it regarding rent. I don't know if this is the number that wasn't working. We'll see. September 8th. Notice regarding defense counsel John Pierce Esquire. This notice is in response to the government's notice filed August 30th. I greatly appreciate the government's expression of compassion and hope for recovery. Good. I am pleased to report that on Sunday, September 5th, I was released from an LA area hospital following a 12-day stay. I was not missing or anything of the sort. But you were, though, because your phones were disconnected and no one could get in touch with you. And I wouldn't have believed this letter wasn't written by the associate until someone I know IRL saw him IRL in court, because I wasn't believing it at all. I was like, how do we know the associate didn't write this? So he's actually been said that he's actually been seen in addition to what he said. Sentences are hard. Words are hard. It's just we're going to be that way tonight. While I'm doing well, my doctor has advised that I not return full-time schedule or participate in any court hearings until Monday, September 13th, as my recuperation continues this week. I expect to be fully operational next week. Have any of you referred to yourself as fully operational? Ever? Ever? Fully operational. I'm fully operational. Sure, guy. Sure. Whew. I cannot begin to express my gratitude to the court, my clients, and counsel for their patience during this time. Get a cell phone and text somebody and tell them where you are. I'm also deeply grateful for the amazing care I received from the doctors, nurses, and staff who cared for me. I would also like to especially thank Ryan Marshall, a young associate at my firm whose admission is pending, his admission to the bar. He's not admitted to the bar, and he has 2 pending felony cases. And the 2 pending felony cases involve court. Look, if you haven't listened to the podcast episode, go listen. It's just sus. It's sus. It's all sus. As I learned for the first time about the confusion and intense media coverage that accompanied my hospitalization, Ryan clearly did an incredible job of appearing in court and not telling them that he wasn't a licensed attorney, but cool. Did a great job showing that he has a grasp of ethics and legal practice. Awesome. Ryan clearly did an incredible job under immensely difficult circumstances with the limited information he had at the time. Why didn't he have information? Why didn't he have information? Oh, and you know what? As we're talking about fully operational, isn't that what they talk about with the Death Star? Like, the Death Star should be fully operational. Like, isn't that like part of Death Star 2 really talking about when it will be fully operational, a fully operational battle station? Like, Jesus fucking Christ with this. Okay. Jesus doesn't deserve that. I'm sorry. I need another expression. What in the actual fuck? We'll go with that. We'll go with what in the actual fuck. So the Death Star is fully operational. Ryan clearly did an incredible job of not telling anyone he wasn't licensed. Ryan did a great job of, getting himself into a whole bunch of trouble with prosecutors. Super excited for Ryan. I bet you that he doesn't get admitted to the bar. So I think that his admission pending is a generous overstatement. The morning I went into the hospital was extremely chaotic. We would love to know, were you in a car accident? Did you have COVID? Were you on a ventilator? Your associate shared so many different options that were still unclear. Mr. Marshall was simply passing along his best and honest understanding of the circumstances surrounding my hospitalization. Were you in a car accident? What? We don't know still. I'm grateful for his stellar efforts and the efforts of my entire law firm. Who's the rest of the law firm? Who? Are any of them licensed? Is there not one other licensed attorney that could have appeared? Oh. I do feel it is important to take issue. Read the room, John Pierce. Now is not the time to take issue with the government. You disappeared. You don't have a cell phone? You can't text somebody? You were that sick that you can't text, and now you're fully operational? No, sir. No, sir. I do feel it's important to take issue with the way the DOJ characterized Mr. Marshall's appearances in court. To the best of my knowledge, well, where were you? You weren't supervising him. All of the judges that Ryan appeared before, is it Mr. Marshall or is it Ryan? Can we pick one? Legal writing 101. If you're going to talk about somebody one way, keep it. Just pick a lane. All of the judges that Ryan appeared before were made aware he is awaiting admission to the bar, but nevertheless approved him to speak on my behalf for purposes of explaining to the court my absence. He went to a reverse proffer hearing That's a little bit more than just telling the judge, Your Honor, I am not an attorney representative. I work for this firm and the attorney is in the hospital. We do not have another licensed attorney to appear. We are unable to make the appearance. I can't even continue it because those are legal proceedings. But that doesn't seem like what happened. I believe Mr. Marshall acted appropriately. Oh, then I've got a whole bunch of fucking questions for you. I'm with the DOJ on this one. I believe Mr. Marshall acted appropriately in explaining to the courts my absence. Okay. And in ensuring Pierce Bainbridge's client's interests were fully protected at all times. You mean the way that they would be if they had a licensed attorney appearing for them in court when they were doing things that were critical proceedings? Maybe that, maybe that. Okay. Moreover, in each instance where Mr. Marshall spoke in my absence, to the best of my knowledge, the DOJ was apprised of Mr. Marshall's admission status and that he was working under my supervision. Pierce, my guy, you can't supervise someone if you are in the hospital and no one knows where the fuck you are, including the person you're supposed to be supervising. It's not like you're on FaceTime with him or even in communication. He didn't know if you had had a car accident, if you had COVID, if you were on a ventilator or not. That's not supervision. He didn't even seem to be in communication with you. Also, John Pierce has not returned to Twitter yet. So there's that. Okay. This case is just a shit show inside of a shit show inside of a dumpster fire, and I'm not leaving it alone until I have answers. I have so many questions, but we're going to talk to people who know him on the podcast, and it's going to be amazing. I cannot wait. Okay, final story. Theranos Trial is still going on. If you are not familiar with Elizabeth Holmes, I've talked about it in the Emily show as well. With regard to that, I should have swooped. Let's swoop to Elizabeth Holmes real quick. Elizabeth Holmes, like any notorious and somewhat famous alleged criminal, has fangirls. I was unaware. People are showing up to waiting to get in line at trial dressed like her or dressed like she used to dress in the all black with the turtleneck with the hair back. And apparently the onlookers, and this is according to Law 360, apparently the onlookers have gotten into some trouble with the court because they've been shouting things at both Elizabeth Holmes and at jurors outside of the courthouse, which you're not allowed to do. So, apparently one of the Elizabeth Holmes fangirls outside shouted at jurors, "Don't forget the hashtag #MeToo movement." Now, because this is a written piece by Law 360, I don't know if they shouted hashtag #MeToo or if they just said "MeToo" and the hashtag was assumed, but it's in quotation marks. So I'm assuming somebody was like, "Don't forget hashtag #MeToo," which is just some what? It's just what? Then a spectator waiting in line to get into court to watch the trial yelled towards Elizabeth Holmes as she walked by, quote, "Congratulations on your little boy. You're a good mom," the woman yelled. Putting everything on one person is ridiculous. Ridiculous. She clearly has fans, which is bananas to have fans outside of court. So as Holmes was waiting through security, jurors were in line behind her to go through security when the person spoke. So that is why it's like you cannot just shout things when jurors are present. Jurors wear like number badges so they can be identified so you know a juror is present. So the judge kicked off the second day of witness testimony with opening statements. Before opening statements, admonishing everyone that what they couldn't do was make statements that could be heard by the jury. What an absolute mess. But it looks like testimony went well this week. They had some of the whistleblowers who testified about being threatened by Theranos's former attorney. And so we are well into the people's case and we are off and away. So yeah, I was not expecting people to show up to essentially a fraud trial in cosplay. That's a new one for me. So yeah, that's weird. It's just weird. Okay, so we need to get into. I'm going to try to do a few super chats, and then so we don't get lost, and then we're going to switch over to the Trisha Paytas defamation suit. And yes, I saw a couple of you compliment the hat. It is my black on black facts hat. It is in the Lawnerd shop at lawnerdshop.com. If you haven't done the likey, subscribey, YouTubey things, please do. I'm going to try to stay on top of super chats the best I can. If I miss them, I will try to sweep them at the end. But we have, over 4,500 people here, so it's going to take me a minute. I do not know anything about Jamie Spears' lawyers being sued, so nope. Sorry, don't. I do not see everything on the internet for sure. And it's been a busy week in Housewives too. So did you know they're not filming the reunion for New York? I just found out on Twitter before I came on. I was shocked. Sounds like the guy had a complete mental breakdown. He had something. But most of the time you can at least send a text. At least. What else? It is so funny to hear you say my name over and over and over in a mad tone. Pierce. It's very stern. And it's the reason I refer to John Pierce by last name so frequently is because I worked with a judge that was a James Pierce, and I don't want people to get confused if I get the name wrong, which, I'm wont to do. Anna said, I'm screaming at my phone. No, it was the deflector shields that were fully operational. That's true. The deflector shields were fully operational on the Death Star. But at one point, was it The Rise of Skywalker? At one point they talked, but it wasn't the Death Star at that point. Then it was the Starkiller base where they talked about it being fully operational. But anyway, yes, nerdy reference. I could absolutely be off. But yes, the operation, the shields, the protector shields. Yeah, shit show inception, Tori, is exactly what it is. So, Ashley said, I've been watching on YouTube, but it wouldn't let me be in the chat. It says subscribers only, yet I'm subscribed. Also, the chat keeps going away. Ashley, I don't know what to tell you. We do have subscribers mode only on because some of the people we're talking about tonight have people that troll them, and we keep our chat friendly. And so we wanted to make sure it was people who were subscribed. But if you are subscribed, YouTube may have unsubscribed you. So be sure to double check that, and then it will let you in. So why is it that John Pierce sounds like he's an accepting award? It does. And I think that basically tells you the Michael Scott level of his personality. It's like, oh, they all really love me. Thank you. It's just, does Pierce believe he lives in Suits? I think so. Even though he went to Harvard Law. This is fair. The Barefoot Claire, no cell phones in mental facilities. That is fair. I would just, I would think that somebody at the facility would have called his law associate, but all of it is so weird. All of the stories are so weird. It's just strange, but it might have been. And you know what? Being an attorney can be very stressful, and mental health is something that should be taken seriously. But if that's the case and you are going to the hospital, someone has to be made aware in some way. Like, look, I am going to be unavailable. I am going to the hospital. It was just a very, very odd situation. And I don't know if he'll ever be forthcoming about it. Okay, so let us get into the Trisha Paytas defamation lawsuit with Anna Campbell. I'm going to give a whole bunch of warnings. Look, this has nothing to do with the other scandals Trisha Paytas is involved in. Trisha Paytas is a defendant in this suit. I don't think Trisha Paytas has even been served yet with this suit, but this suit, a lot, and by a lot, I mean a lot, has happened in court since this lawsuit was filed on August 18th. It has been active litigation, but it still does not seem that Trish has been served. Also, there are times that I will switch back and forth. I know that on social media, Trish has both they, them, and she, her pronouns in her bios. I always try to respect and will always respect people's pronouns, but she does have both in there. And I've followed Trish on social off and on for quite a while. So I will always try to do my best. But also when they changed their socials to be they, them, she, her, I was like, okay, well, we're just all of it. We're just all of it. either way, the case with Anna Campbell deals with sensitive relational violence topics. I'm sure a lot of you followed what went on when former girlfriends of Anna Campbell had made videos about their alleged abuse and had talked about their experiences being in a relationship with Anna Campbell. Anna Campbell then sued them and Trisha Paytas for those conversations. So when we talk about the statements of defamation, there are quite a lot of names, all of the names the names for people who like people that are underage, the names for people who choose to have sex with people who are not willing or consenting, all of the names. And that is the underlying allegations in the defamation suit. So the defamation suit is arising out of that. Anna Campbell is another social media influencer. All of the individuals in this are social media influencers. Trisha Paytas is one of the defendants. There are 8 counts in this complaint. Trisha is only charged in 5 of the 8. The counts in this case, and we'll be going over the complaint in just a second, are defamation, wiretapping, invasion of privacy, IIED, which is intentional infliction of emotional distress, NIED, which is negligent infliction of emotional distress, tortious interference with business relationships, which we're going to be talking about later because the lawyers for Novian and Novian couldn't plead that right. And Ethan Klein's lawyers were like, yep, we can do that. Civil conspiracy and unjust enrichment, which is a very interesting claim when it's YouTubers monetizing videos talking about other YouTubers. It's very interesting to see an unjust enrichment. It's like, hey, they shouldn't be monetizing talking about me. They're violating my privacy. They've done all this other stuff, which is very, very interesting. So again, this is a complaint. Lawsuits are allegations and shade. Allegations and shade mean that these things have not been proven true in a court of law. This is what people have said. It is literally they said, they said, they said, they said. So that is what it is. Let me see. The first page of this, I'm not going to go through the first page. The first page of this lawsuit, they put everybody's home address in it, and I have not redacted. This one's not my redacted one, so I will not be pulling up the first page. Look, these are public records, but let's remember that doxing is shitty, and no one deserves that. And you can do this without putting people's home addresses in there, though Anna Campbell put her own home address in there, it seems. And again, I did not Google these addresses. They look like home addresses, but you can plead these with people living in a city and state. You don't have to put their addresses in there unless Massachusetts has a quirk and they require it. So this is filed in the Commonwealth of Massachusetts. This is plaintiff Anna Campbell, a resident of Massachusetts, Ashley Fiesel, a resident of California, Kaylee Pillow, a resident of California, Taylor Pendergraph, a resident of Ohio. Let's see, Madison Grossman, a resident of New York, and Trisha Paytas, a resident of California. These are all, again, this is a state action in Massachusetts. I think what do we see first, friends? I have jurisdiction questions. Now, the reason you can't have diversity jurisdiction in federal court is because 3 of these individuals are in California. So there's not complete diversity of parties because you have so many Californians. Interesting, when we talk about the defamation causes of action, Massachusetts has a very interesting defamation statute and a very, very, very limited anti-SLAPP statute that won't apply here, and we'll talk about that in a minute. So really, Fred, you're just doing it? Yeah, okay, go. Pondered Fred's just having a moment. We're going to talk all about defamation. All right. So let's get into this. Anna Campbell's a young woman in her 20s. These are the facts. We're the facts section. And they say that jurisdiction's proper in Massachusetts. I have questions. I have questions about the jurisdiction element, but a lot has happened. We're just going to go to the allegations first with regard to this defamation suit. Anna Campbell's a young woman in her 20s who resides in Massachusetts. I'm glad she has a bachelor. Like, why do I don't need her resume, but cool. She has a Bachelor of Science in Psychology and has previously worked in a hospital as a mental health specialist. For the past decade, she has created online content since she was 10, 11. Really? Maybe. Oh, okay. Okay. Over time, her online content and quote posts have become popular, received millions of views by people online, and developed many followers, meaning people that subscribe via an online platform that to regularly receive notice of and view her online content. I love lawyers trying to explain the internet to people. It's one of my favorite things. It's one of my favorite things. The subject matter of her online posting is diverse, but one subject area that she is well known for is her content regarding mental health. Okay. Ms. Campbell derives income from her online posting or her posting online and has acquired sponsorship deals and agreements with companies who wish Ms. Campbell to promote, advertise, and discuss their products and services through her online presence. This is the most lawyerly way to try to explain the internet. Just okay. This has become her primary and sole source of income. Well, is it primary or is it sole? Because primary means one of several and sole means only. So those things seem to be illogical, but Fred is kicking me. Fred, you can't kick me. Miss Campbell is an open bisexual. She has had relationships openly with women. Great. She has had personal, I guess they do need to explain it because if you don't explain, because numerous of the women that she's suing, she has had relationships with. And if you don't explain the relationship, the judge is not going to understand that it's depending on the judge, that it's a romantic relationship and not just a relational friendship. So I guess it's necessary to explain. She has had personal relationships. So I think intimate partner relationships is probably the words that they're looking for, because it seems like this is all stemming out of intimate partner relationships. She has had personal relationships with 4 of the defendants in the past, including Fiesel, Pillow, Grossman, and Pendergraph. Relationship defendants. Oh, they got grouped together. While Miss Campbell had intimate relationships with the women, she never had intimate or sexual relationships with Grossman. Okay. So I guess we've clarified, but Grossman's up here in the personal relationships. So, all right. I'm confused by that grouping, but it's probably not super relevant at the moment. I don't think. During the relationships, the relationship defendants came to know private things about her that she did not intend to share with the greater public. Look, she's been on the interwebs for 10 years creating content. Things that you share with other people, though you may want them to remain private, the other party doesn't have an obligation to keep them private. There are very limited things that would fall under, you can't disclose that. But it is very difficult to say they became aware of things in her private life and then they shared those things. Yeah. That's how that works. You don't really have an expectation of privacy in things you've shared with another person unless that person has a duty to keep it private, like a religious leader or a lawyer or a doctor or a spouse. Okay. But this is establishing, because there is a invasion of privacy claim. This is starting to go towards that invasion of privacy. During Campbell's relationship with the relationship defendants, no, just one of them, Pillow. Pillow secretly and without Campbell's consent recorded her audio visually on her cell phone numerous times while Campbell was in an emotional state and they were having private conversations about their relationship and Campbell's mental state. These recordings were ultimately shared to social media by Pillow and widely viewed and disseminated across multiple online platforms. I know none of that about any of that. The recordings have been viewed hundreds of thousands of times, but they didn't link any of the videos, which I guess because I get they don't want that to be discussed. But also, if you're going to say that those things are an invasion of privacy, you kind of have to at some point submit that to the court as evidence. The relationship defendants like Campbell also have large online presences because there's multiple, but all right. They each have many thousands of followers, subscribers, and viewers across multiple online platforms. to which they post content, including but not limited to YouTube, Twitter, Instagram, TikTok. Over the past year, they individually and in concert, because there is a claim with regard to conspiracy, because apparently the exes made videos together saying, look, we are the victims of this person, and these are our stories. Listen. So that is being alleged as a conspiracy here. They allege here that the relationship defendants targeted Campbell through an ongoing and persistent online social media campaign, throughout which they post written and audiovisual content across multiple platforms about Campbell that is negative, harmful, false, demeaning, and or malicious. Trisha Paytas is a social media personality who has many thousands of fans and viewers. I would hasten to say millions when it comes to Trisha, but okay. Across her various online channels and platforms. On her YouTube channel alone, she has over 5 million subscribers with almost 2 billion views. Right. More than many thousands. Also, you know what? It feels like Trish is just lumped in here because of the context, but it's a very interesting thing because Trish isn't charged in conspiracy. So I don't even know how they're going to move forward with Trish joined in with all these other defendants, because there's not like aiding and abetting defamation like that. It feels trillery to me. Anna was labeled, okay, all the words, the P word that'll get me demonetized immediately, an abuser, a rapist, a racist, a groomer. We're just gonna live that yellow life here on YouTube. We're talking about legal documents. We're not saying these things are okay. We all equivocally agree all those things are bad, but also name calling is bad. Some of the defendants' posts online include statements regarding Twitter statements regarding self-harm, which is not defamatory. So I don't know why that's in here. This is a defamation suit. Defendant Pillow allegedly say, I will send every school where you live what you did. Pedos, rapists, and abusers don't get away, and I will not stop. Again, when it comes to defamation, there's going to be an argument over proving whether these things were these women's experience or not. And this is going to get very Johnny Depp very fast as to whether you can prove, was it true or was it defamatory? And then for the women who have alleged this harm by Anna Campbell, if it is not true, then we're in the realm of like defamation per se. If this is their experiences, they will then defend themselves by saying, no, this is what happened to me. And all of it will just, all will be out. Defendant Pillow in a similar video with similar content on Instagram stated, your whole name and everything about you is ruined. You can't get a job. If anyone else searches for you, I'm after you. You want to give me a felony charge? Guess what? I will show any school that you are a pedo. You will get to leave the internet. You don't get to say, I'm going to school now. No, you're not. You're going to jail. If Taylor can't take you to jail, I can. I have video proof and more. Okay. Defendant Pendergraph said on Twitter, if they were false RAPE allegations, Anna should have taken me to court for defamation immediately, but she didn't. Well, that was posted July 17th, 2021. I wonder why, and it's not because of it being, quote, expensive. Money wouldn't matter when your entire reputation is on the line. Well, I mean, I don't know if that statement's defamatory because it's just saying, if you think my allegations are false, fucking sue me. Again, that statement's not defamatory. Okay. Defendant Pendergraph is allegedly called Anna Campbell a pedo. From a YouTube video posted, it says, Anna is a danger to herself and society and young girls that do not know any better. This video is called Anna Campbell is Dangerous. Again, I don't know if danger to herself is going to be considered defamatory. Defendant Fiesel posted a video on July 14th saying, just in case there is anyone that still does not believe Anna Campbell is an abuser simply because she is a woman, let me remind you what we are dealing with. The video shows Anna Campbell boxing. Okay, but if that was somebody's experience, again, truth is a defense to defamation, and it's going to be interesting. Defendant Grossman said on Twitter, apparently, Anna Campbell, you are a RAPIST. Anna Campbell, you are a physical, emotional, and mental abuser. You are a groomer. We will get justice. Fuck you. I mean, if that's not true, at least it's a very solid, tangible statement. What I'm not seeing is anything that, oh, here we go. Trisha Paytas posted a YouTube video on August 5th in which she stated Anna Campbell is disturbed and uses her platform to speak with minors. Not defamatory. Referring to Miss Campbell with minors, you ruined them, you groomed them. I mean, you got in with them, you were friendly with them, did all this stuff and got close to them. But this August 5th video is after all these other videos of people who had relational partner relationships with Anna Campbell. So when it comes to Trisha's statements, here's what I want you to think of, because you're law nerds and we're talking about it. Part of a defense to defamation is going to be, did someone have a reasonable belief that the things were true? And you have multiple individuals coming forward saying, this was my experience with this person. So is it on Trish if she is believing what other person said and then asking those questions, saying, I mean, I guess she didn't say, it seems that Anna Campbell is using her platform to speak with minors, according to these people. It seems that she ruined them. These are stronger statements, and these are maybe not reporting, but it's going to be very interesting to see how this plays. And I just don't think she's also a properly joined defendant. It's kind of a mess. But she said you ruined them, you groomed them, you got in with them, you were friendly with them, did all this stuff to them, got in close with them, and then when they got to a certain age, you got sexual with them. That's grooming. You were disgusting. How is she not in jail? She should be too. And then she talked about what somebody else had said. One of the defendants is one of the ones that was underage talking to Anna, and then when she turned 18, it became sexual. You're sick in the head and no amount of medication can fix it. To date, the video has over 246,000 views. The video spawned other social media personalities to make videos wherein they comment and opine on Trisha's video about Miss Campbell. But Trisha is commenting and opining as well. And also, it's very interesting to see how all these defendants are joined together. So I don't know. I don't know how these defendants are properly joined. So they talk about another YouTube video where the ex-relational partners did a video together, said, we are survivors, posted on June 28th, 2021. It has over 900,000 views. It's over 10 minutes in length. They say that they're the exes of Anna Campbell, and this is our truth. Again, how are they going to prove it's not their truth? To prove that it's defamatory. You have 4 people in a video together saying this is our truth. I don't know how Anna Campbell is going to prove that it's not their truth, other than, well, I say it's not. And the 4 of them are like, well, we say that it is. And I will talk about the Massachusetts statute in a minute, because it is more similar to the Johnny Depp Europe situation, where it has to be more than likely substantially true. It's not a like, prove it's absolutely true. It has to be substantially true. And when people say, this was my experience, and then Trisha repeats that, is that defamatory? I mean, again, if you call somebody these names out of the blue with no evidence, it's different. But when you have people coming forward saying, this is what was done to me, it's different. Ms. Campbell denies the above outlined statements by defendants, as well as the multitude of others they've made. This is negative, harmful, false, demeaning, and or malicious content about Ms. Campbell. Oh, yeah, I'm sure it feels that way, for sure. The defendants are supportive of each other through online social media platforms and sharing and communicating the negative, harmful, demeaning, and or malicious content, of course. The defendants have continued to share and post and disseminate negative, harmful, and false to this day. The results of the defendant's actions, Ms. Campbell's reputation has been harmed. I don't doubt that that's true. Her followers and subscribers have dropped since the We Are Survivor videos was posted by defendants. Ms. Campbell's lost over 11,000 subscribers on her channels. I don't know how big her channels are and whether that's significant or not. If she has millions, it's not. If she has like 50,000, it is. So I don't know the significance of 11,000 subscribers because I don't know the size of her channel, and they don't say. And she lost over 13 alone in one day. The video was posted. Again, losing 1,000 subscribers in a day, depending on the size of your channel, might not be the most significant. Further, the actions of defendants have spurred thousands of online comments and videos from other third parties. And then this talks about the comments that were gotten just to show harm in Massachusetts. They go on to say Ms. Campbell's experienced emotion and physical distress as a result of the actions. This doesn't specifically plead it. I don't know what Massachusetts rule is for specifically pleading IIED and NIED. Again, intentional infliction of emotional distress, negligent infliction of emotional distress. In some jurisdictions, you're required to say, because of this, this person has had anxiety, migraines, loss of sleep, and you have to plead the things, not just that they generally as a catch-all had emotional and physical distress. So I don't know in Massachusetts how detailed they need to be, but it says she sought medical attention and has incurred medical bills with regard to the physical stress of the thing. Campbell's income and relationships and agreements with sponsors have been interrupted and adversely affected. I imagine that they would be. On August 16th, she was suspended by the YouTube Partnership Program. Interesting. Due to the actions of the defendants. Well, how do you prove that? Did YouTube say it? Does YouTube give you a hint now as to why they've suspended you? Because if YouTube said it was because of violations, then like if YouTube says it's violations of the creator code of conduct, how do you pin that on the defendants? Because if they're saying, no, it's based on your behavior. So I'd be interested if YouTube ever gave reasoning, because they don't always. And I'd be interested how they're going to prove that YouTube suspended her because of defendants. Here's another mention of Trisha. As another example, defendant Paytas instructed her viewers to unsubscribe to Campbell's social media accounts, thereby depriving Campbell of income. Well, Trisha can say what she wants. Just like Ethan can say, go leave a Triller, go leave a review. If you think it sucks, fine. If you think it's great, fine. Go tell them what you think. I mean, I don't think calling to deplatform someone is actionable. It's sometimes and often distasteful, but I don't think it's civilly actionable. I wonder if they're gonna try to work that into the interference with business relationships, the intentional interference. As a result of posting online comment about Campbell, defendants have deprived more followers, more viewers, and more income as a result. Defendants have deprived Campbell of more followers, more viewers. Well, it's not all about the followers and viewers. Or is it? Defendants have been enriched by their use of Miss Campbell's name. This is an interesting one that I like. I mean, not that I like any of this, but when we're looking at legal arguments, when it comes to potential or alleged defamation online, the unjust enrichment angle is one that I have not seen yet. And it is very interesting because the argument goes like this. You said defamatory shit about me. And because you said defamatory shit about me on your channel, you got more clicks, views, likes, and AdSense. So let's look at the AdSense for those videos about me. You were unjustly enriched in the videos where you talked shit about me. Todd Chrisley, are you taking notes? Unjust enrichment. Unjust enrichment is a very interesting way to go about this. I mean, I like the cause of action. I don't necessarily like this lawsuit, but I like the cause of action. So let's keep going. Through correspondence from undersigned counsel on July 22nd, Campbell served defendants Fiesel, Pendergraph, and Pillow with a cease and desist letter requesting that they cease any and all online activity regarding Campbell and advising them of their violations of the law as outlined in complaint. The defendants have not stopped. Well, yes, that goes that way. This is how this went. Cease and desist talking about me. And they went, no, it's true. We didn't defame you. And they went, okay, well, we told you to cease and desist. So now we're going to sue you. And here we are. Count 1, defamation against all defendants, incorporates everything above, Defendants made and published false statements without privilege. Privilege in the context of defamation means things like litigation privilege, where you can say things that are privileged statements that are protected, so they are therefore not defamatory. So it can't be a privileged statement. Some reporting, well, most reporting is covered by privilege, things like that. So that's what they mean when they talk about a privileged statement. Some of the statements some of the statements allege that she committed a crime, which can, by the way, be defamation per se. Massachusetts blends the two statutes together. Defamation per se is when the defamation or the defamatory thing is known to be reputationally damaging. Calling someone a pedo, calling someone an R word, those are things that in society we go, no, that would be reputationally damaging if it is said about you, if it is not true. I mean, if it is true, it's also reputationally damaging, but it's not defamatory. So you don't have to prove damages the same way because it's known to be reputationally damaging. And that is the point of, defamation. They don't want people dueling anymore. Sorry, my kid is studying Hamilton at school, so duels are on the top of my mind. They don't want people dueling in the streets over their reputation anymore. They have to go to the court system and fight about it there. Defendants either knew the statements were false or acted in reckless disregard as to whether the statements were true or false. And this is what's interesting. When it comes to Trisha Paytas' statements, in this context, would Trisha have known the statements were false or acted recklessly as to whether the statements were false when there are 4 people coming forward who are relational partners saying, this is my experience? Is that acted in reckless disregard? Because I don't know how you prove that one to me. I don't know how you prove that that's reckless disregard to me when there are 4 people who said, I was in a relationship with this person. This is my experience. The false statements made by defendants concerning Campbell have caused harm to her reputation. I mean, that's probably going to be the easiest part to prove. Impact economically might be harder. Count 2, wiretapping violations, which is very interesting. Campbell was audiovisually recorded by defendant Pillow without their consent. It depends on how that went down, if they were recording in person, if they were recording a phone call. So the facts of that are going to need to be specific, and it will be interesting to see. They did not plead very specific facts on this. Invasion of privacy. They disseminated facts of a private nature. Examples include Ms. Campbell sharing feelings of self-harm and private sexual text message conversations. I don't know if that is, I don't know if that's going to fly for invasion of privacy, because no, I'm just, you know what? It's not going to fly for invasion of privacy, because those were things shared with the individual. So they didn't go and get into someone's computer or derive the thoughts of self-harm. They didn't get onto their phone illegally and go, oh, this is what they're doing. They didn't access computer files. They didn't invade the privacy. These were things that were shared with them that is distasteful to share, but also this is not an invasion of privacy when it's information shared with you. We also saw this in the Swanson case, where Swanson was alleging invasion of privacy when apparently James Westbrook was talking about a medication he was on. But it's like, how would you even know if they didn't tell you? So how is this an invasion of privacy when you told them? You just told them. So they didn't invade your privacy to get that information. So normally I'm not just like right out the gate, but based on everything pled, that one's a loser. Count 4, IIED. By saying all the shit that they said, it caused emotional well-being, that the conduct was extreme and outrageous and was beyond all possible bounds of decency and utterly intolerable in a civilized society. Well, if the things aren't true, then maybe. I think that allegations of P word and RAPE and all the things, I think still are intolerable to make those false allegations in a civilized society. But that is going to pin on whether the allegations are false. which is what Anna Campbell is alleging. The defendants in their statements that came up later in their declarations are saying, no, this shit's true. So we good, because it's not defamatory. And if it's not defamatory, then it's not going to be IIED or NIED. NIED is the negligent little brother of IIED, little harder to prove, generally less damages and what have you. Tortious interference with a business relationship. We're going to talk about this more as we get to the H3 stuff. But yes, this is to all defendants. So it includes Trisha Paytas, because her primary source of income is derived from online follower traffic to YouTube and other socials, which she receives sponsorships agreements. So this is just going to sponsorships, but it doesn't look like they're talking about her being removed from the partner program. Defendants should have known that their negative comments would adversely affect her online presence. I would say that based on the tweets that are alleged here, that was their intention. But again, that pins on, it's not tortious if there isn't an underlying tort. And here the underlying tort they're saying is defamation. And if the underlying tort doesn't exist, this doesn't exist either. Civil conspiracy versus Pillow, Pendergraph, and Fiesel for the video that they did together. Unjust enrichment, which again, though I think that this is going to pin on the experiences of these women, the unjust enrichment being pled with regards to defamation in the online space to get more views to your YouTube channel is a novel approach to this. And I appreciate that perspective. And I won't be surprised if we see that in other jurisdictions as well, where it is, as a result of their posting, they earned income for the shit that they said and have been enriched by the use of her name. I'm going to have to look and see if there's case law on this and in the online context with unjust enrichment and defamation in like the YouTube sphere. You've just seen me go full nerd, because it's a really interesting argument that if you're saying things that are defamatory, and again, this is alleged that they're defamatory, the defendants in this case are saying, no, I said what I said and it's true. So you said, but if it is proven that you said things that were defamatory and it's proven that you ran 10 YouTube videos, 20 YouTube videos, 600 YouTube videos, whatever it is, with statements in them, then is all the income from those statements unjust enrichment, because you wouldn't have maybe driven the same amount of clicks or views if you hadn't made those statements or weren't talking about that person. And that's a very, very interesting legal position to me. The judgment entered in their favor, reasonable attorney's fees, costs, and other such relief. So not a big plea for damage, not a amount of money put on it, through their lawyers, verified. And then they posted some of the tweets in the worst photocopy I've ever fucking seen. And these aren't, I think there is a declaration that was submitted saying, I screenshotted these off of Twitter, it's accurate. I don't know if that's going to be enough for a verified complaint that those Twitter allegations are the truth, but at least they tried to lay foundation for them with the verification from Anna Campbell. And she is verifying the complaint and verifying that those are accurate reproductions off of Twitter. Probably not the biggest problem in this case. I think there are other issues. So since this was filed on August 18th, 2021, quite a lot has happened in court, and we're going to talk about that. On August 18th, there was also a request for a preliminary injunction that was filed by Anna Campbell's lawyers, and it's literally a request to keep my name out of your mouth. And this was granted. We're flipping to the last page of the book. This was granted like yesterday. So the request for preliminary injunction is against all defendants, saying that the action arises from the voluminous online dissemination of malicious, false, negative, harmful, and or demeaning content about Campbell by the defendants via numerous online platforms, YouTube, Twitter, Insta, TikTok. Defendants have been posting material about Campbell for over a year and continue to do so. A preliminary injunction enjoining defendants from posting and sharing the harmful content online is necessary to protect Campbell from ongoing, imminent, and further harm. For the reasons stated in defendant's memorandum of law and support, and referred to and incorporated by reference, plaintiff is likely to succeed on the merits of her claim Plaintiff will suffer immediate and irreparable harm without the requested relief, which is very, very interesting. She then put in a memorandum that had a lot more specificity with the allegations in this case, and a number of the defendants responded. So defendant Fiesel responded and asked for an extension, and the court said no. Defendant Fiesel then put in an affidavit and said, I said what I said, and it's true. So they're not likely, Anna Campbell's not likely to succeed on the merits because what I said is true. Pillow also put in an affidavit. And the reason I'm not pulling them up is because they are A, very detailed in a way that could be triggering, and B, they do have home addresses in them, but they are very similar in that I said what I said. This is my experience. It's true. And this is what she did to me. For example, in the Pillow declaration, she said that in December 2019, she began making and posting videos on YouTube, began a romantic relationship with Anna Campbell. During the relationship, Campbell supplied her with hard drugs. Of the drugs she pressured her into doing, one was Xanax. Xanax was a prescription that Campbell had for herself. I'm currently receiving treatment for substance abuse that stemmed from the relationship with Campbell. And these are the things that were said in these videos and tweets. On June 28th, 21, I learned, after learning and talking to other romantic partners at Campbell, I, along with two others, were recorded a video describing our relationship and the incidents of abuse that they received. The instances of abuse cited in the video were supported by pictures, texts, or videos that showed the acts being discussed. The purpose of the video is to raise awareness for abuse victims, to share my personal experiences, and let others who are experiencing similar situations know that there are avenues to seek help. This video was not designed to make money for the creators involved in making it, which goes to that unjust enrichment claim. The method was provided for individuals who viewed the video to donate. A method was provided for individuals who viewed the video to donate money to the Global Recovery Initiative Foundation, an organization for recovering addicts. The June 28th, 2021 video attributed to me in the complaint did not contain any false information. All statements referred to Ms. Campbell were supported by evidence. None of the information given regarding Ms. Campbell was private. So that is hey, you can't grant the preliminary injunction because you're not likely to win on the merits, because what I said is not defamatory, because what I said is true. Pendergraph did a motion to dismiss, argued that she was not properly served, and then went on and put in her own declaration saying that I was never served. And I don't live in the jurisdiction, like you don't have authority over me. I'm not in the jurisdiction of Massachusetts. All of that aside, on the 16th, which was yesterday, the court granted this PI against all defendants, which is really, really interesting to me because there's not a lot of specificity to it. This is the court order. Preliminary injunction. Defendants Pillow, Pendergraph, Fiesel, Grossman, and Paytas are enjoined from publicly referencing, referring, or writing about Anna Campbell, or directing anyone else to reference, refer, or write about Anna Campbell on any online platform to any media outlet during the pendency of this case or further order of the court. Anna Campbell is enjoined from publicly referencing, referring, or writing about any of the defendants or directing anyone to do such to any online platform or media outlet during the pendency of this case. But what it doesn't address is, what about what was already said? So is this future? Does this include the videos that are already up? It doesn't say. And Trisha hasn't been served in this. So how is a Massachusetts court going to enforce an injunction over a party it doesn't have jurisdiction over yet? I don't know. I'm fascinated to find out. I think there are jurisdictional issues. I think there are joinder issues. I'm confused as to why this judge was like, yeah, we'll just grant this injunction. Nobody can talk about anybody. And maybe it's because they don't see harm in it, because look, you're now in litigation together. You shouldn't be talking about each other anyway. It'll be very interesting. There's no further reasoning. You saw the whole thing. So that is going to pop off. I would be... let me see. Two things. I'm going to cover a little bit about the Massachusetts defamation statute and the anti-SLAPP statute. And then we're going to move on to H3 stuff because I've been talking forever and we need to get to that. So let me pull up the statute because it was actually contained in the memorandum of support for the injunction. And I just want to get past the part that has addresses in it and get to the part that cites all the law, which, by the way, 10 out of 10. If this is a rule for Massachusetts, God bless you, Massachusetts. We love this rule where you have to attach the law that you are saying that you will win under to the motion. It's just so fucking helpful for all of us legal commentators. All jurisdictions should do this. I bet it's super helpful for the judge too. It's like, look, this is what defamation means in Massachusetts. Look, here's all 5 elements and the case that they came from. Brilliant. Thank you, Massachusetts. If this is a local court rule, thumbs up. Everyone should do this for preliminary injunctions. Do this. So, first, a defamatory statement. Okay. Shit that, is false. About the plaintiff, published without privilege to a third party. So, it has to be said to someone, and it can't be a privileged statement like litigation privilege and reporting, things like that. With fault of at least negligence on the part of the defendant. So they have to be at least negligent in saying the shit that's alleged to not be true, that the statement caused the plaintiff economic loss or was of the type that is actionable without proof of economic loss, defamation per se. So they've combined defamation and defamation per se into one statute. So if it's things like the pedo allegations and those kinds of allegations of crime, they are so outrageous that you don't need to prove economic loss. And then as to the other stuff, it would be proving economic loss. But that is their defamation statute. What's very interesting about this, and the reason I would want to fight jurisdiction in Massachusetts, is what does that statute not say anywhere? Malice. It does not say if you are a public figure, there must be malice. The only malice that I can find in the Massachusetts statute is with regard to public officials, an elected public official. That is the only time you have to show that the statement was malicious. Most of the time, defamation is really hard to go after because you have to prove not that you just said shit that wasn't true, not that it caused reputational damage, but as to a public figure that there was actual malice, actual like, fuck you behind it. But that's not required in Massachusetts. I think making it easier for a public figure to prove defamation against them. The other thing in Massachusetts that really goes not in the favor of the defendants is that the anti-SLAPP statute is severely limited. And the anti-SLAPP statute, Emily, what's an anti-SLAPP statute? Why, thank you. Law nerds, thank you. You remind me to bring it up. Anti-SLAPP statute. Anti-SLAPP means SLAPP means strategic litigation against public participation. So it means that you are suing someone to make them shut the fuck up because they are participating in the public in a First Amendment way. So it's a strategic litigation against public participation. So you are using the weight, or you are using the weight of the court and the money that you have to railroad over someone in court to get them to shut up. Anti-SLAPP statutes is a statute that you can bring. You can use the anti-SLAPP laws to bring a motion very early in the litigation procedure before there's any discovery to say, look, your case is so defective on its face. It's obviously designed just to shut me up. You're never going to win. So the whole thing should be dismissed and you have to pay my attorney's fees. Some states have a very strong anti-SLAPP statute, which means it's easy for a defendant to win an anti-SLAPP by going to court and saying, look at what they said, they can't win on their face. This is what happened in the Keemstar Romeo Lacoste, and Keem ended up taking his play button as part of the attorney fee award. He used the anti-SLAPP statute in California to his advantage when he got sued for tortious interference and a few other things. In Massachusetts, the only part of the anti-SLAPP statute is that it protects the right to petition government. So if you are petitioning government and you are sued because you are asking government to do something, you can use the anti-SLAPP statute. Otherwise, you're out of luck. No anti-SLAPP statute. So if I'm a California defendant, I'm like, I don't live in Massachusetts. I said shit about you on the internet. I've never been to Massachusetts. I never came to you. I have no jurisdiction here. Come sue me in California. Bet you fucking won't, because I'll just file an anti-SLAPP motion, which, guess what? Ethan did. So we're going to be talking about that in the H3 case to to go with the anti-slap. So Kibbe said, so basically this filing is thrown out. No, this filing can't be thrown out. Because the anti-slap statute in Massachusetts is not in the favor of defendants in Massachusetts at all, unless it's public participation in petitioning government, which is very interesting. I've not seen an anti-slap constructed that way. I think it's very interesting that they don't have a malice component. And I think that you need to know, if you're going to defame people in Massachusetts, you need to be aware, because that malice component is what makes defamation hard. So, yep. I think that we will get motions to dismiss on jurisdiction in this. I mean, at least I hope we will, because this is I don't think they're properly joined, and I think there's a lot of issues with the co-defendants and a lot of issues with jurisdictions. Again, it feels very Trillery. Speaking of Triller, are you ready? Because it's Triller night. Are we ready to get on to Triller? So that's Trisha Paytas being sued for defamation, though it doesn't seem she's been served yet, and is now under a protective order that I don't think the court can enforce, because I don't think the court has jurisdiction under any of these parties. But if I was any of the parties, I would shut the fuck up and let my lawyers figure it out. I would not want to talk about this at all, which is part of the reason I brought it up, because I don't think the parties engaged in this will talk about it at all as proper. It's proper that they don't. There's a lot here. We're going to follow along with this one if you guys want to see what happens. But when we get to YouTubers and things, we're going to keep talking about defamation, because it's the internet, and people are going to keep suing for defamation. So we should just let me pull up my Google Drive with Triller. There's so many cases. I'm going to give a brief road so far. If you guys are here, foot soldiers, beautiful bastards, if you are here to hear this, just put a 1 in the chat if you are ready to talk about the Triller lawsuits, because good God with this. And again, I think Ethan's lawyers have done a great job. I think that Triller's lawyers have just not. They have not. All right, we're moving on to water for this. We're going to do the motion to dismiss first, and then we're going to do the anti-slap motion, because remember, there are 2 lawsuits here. So let's just... 2. So Triller is an app that's allegedly flipped, and it hosted the Ben Askren Logan Paul fight. Who the fuck fought? The fight was so long ago. My mind is blank on who. No, we'll pull it up. But it's over the Ben Askren, Logan Paul, Jake Paul, one of the Paul brothers had a fight. It was a live event. There were musical acts. And H3 went on H3 and said that fight sucked. And here's a clip of the fight. And it looks like the ref called it too quick. And it was a terrible fight. And they did that commentary a number of days after the fight actually aired. The original lawsuit in this, Triller sued a whole bunch of people, including Film Daily, and a very, very fantastic and sassy federal judge went, literally, what the fuck is this? Because to me, it looks like improper joinder, and I need you to make it make sense how this all works, and excoriated the Triller lawyers. So then they filed an amended complaint and added the H3 podcast to it, but didn't take out the other defendants. And then the judge said, eventually, there's videos on all of this. Eventually, the judge was like, fuck this shit. I'm dismissing all the other defendants. And Triller has resued some of them, but not all of them. I don't think Mike's been resued. Mike. They sued YouTube channel Mike. Mike actually re-uploaded the fight if they ever find whoever that YouTube channel is, which I don't think they can. But if they ever found who Mike was, Mike actually re-uploaded the entire fight. And they, in 2 different lawsuits now, are trying to sue the H3 podcast company, the production company, Ethan Klein, and now Hila Klein, and also Teddy Fresh, the separate company that does the clothes. In the original Triller lawsuit, it's regarding alleged copyright infringement and more, with regard to the re-upload of this fight, and we'll get into it. With regard to the second lawsuit in state court in California, it's essentially a defamation suit, though those are not the specific causes of action, saying, Ethan said mean things about me. Yeah. And his subreddit made fun of me, and they said that Ryan Kavanaugh, the majority owner of Triller, looked like well, we'll get there. We'll get there. You know what I mean. We'll get to Ryan Kavanaugh. So let's get into the motion to dismiss first. The motion to dismiss is with regard to the federal cause of action, with regard to the fight, not with regard to the hurt feelings of Ryan Kavanaugh. We'll get to that next. There is definitely lots of sass in this. Oh, man. All right. Let's go. We're going to this is the motion to dismiss pursuant to 12b-6. We love a 12b-6 motion, don't we just so much? And please take notice on November 22nd, so we don't have to wait like a year. We get to actually hear this in November, that this will be held before Judge Kronstadt, because this is Central District of California. Great. The motion to dismiss is made on the grounds that, one, plaintiff's claim for copyright infringement fails to state a claim, fails as a matter of law under the doctrine of fair use. Accurate. Plaintiff's claim for vicarious copyright infringement fails to state a claim, fails as a matter of law under fair use. Also accurate. Plaintiff's claim for violation of 47 USC section 605 of the Federal Communication Act fails to state sufficient facts to plausibly state a claim. I still don't understand what they're trying to allege with the Federal Communications Act, because it literally made no sense, and it still doesn't make sense. Hence the 12b-6 motion to dismiss. Here's what I love about this motion. Look, they cited the rule 12b-6 instead of saying motion to dismiss, there's a murderous conspiracy. So we already love this out of the gate. I don't hate all motions to dismiss. I just hate some motions to dismiss. Not all of them. Not all of them. I'm waiting for Triller to actually allege a murderous conspiracy. I'm waiting for it to pop into one of these motions. I'm sure it will. All right, let's get into the actual motion. Look at our gorgeous table of contents. God, it's so nice in a federal case to have an actual table of contents with the law all laid out. Thank you, law. Memorandum of points and authorities. The second amended complaint of Plaintiff Triller Fight Club. Yeah, they keep filing amended complaints. Is fatally defective on its face. Yeah. The second amended complaint, so you're gonna see SAC. The second amended, oh dear. It just sounds dirty when I say it that way to me. We're still gonna call it the SAC. The SAC. Triller's SAC. Give that SAC the respect that it deserves. Triller's SAC is Triller's fifth attempt to draft a well-pleaded complaint regarding defendants. My note was this, and it still is not a well-pleaded complaint. And yes, this is their fifth attempt. Would you like a recital of how this is their fifth attempt? Good, me too. Oh, damn it. It's not down in the footnote. They get into it. The term defendants means TED Entertainment Inc., which is the company that runs the podcast. It's their production company. Teddy Fresh Inc., Ethan, and Hila Klein. I love when we get into the fifth attempt at filing. All right. Fifth attempt at a well-pleaded complaint regarding to defendants' critical use of Triller's broadcast of the Jake Paul Ben Askren fight in the TEI-produced H3 podcast, despite numerous opportunities. Triller's SAC constantly files complaints that are a mangled and mangy mess devoid of any merit. We appreciate the shade. If you notice my lines are all wobbly, I was on the plane reading this. Triller's persistent failure to properly plead a complaint is particularly egregious in light of the fact that they should have just stopped. In response to Triller's previous attempts, the Honorable Percy Anderson, we stan Percy Anderson, Percy was having none of it. None of it at all. The Honorable Percy Anderson dismissed defendants sua sponte. Here's why this is shade. Because it means that the judge did it on their own motion. The judge said, hey, this is so bad that we're not going any further. What we're not going to do in my courtroom is bring this shit. So sua sponte is a big deal. Is a big deal. For improper joinder, because Triller relied on, quote, I love that they're quoting the other federal judge to this federal judge. It's like, yo, Your Honor, you know the judge down the hall that you really like, Judge Anderson, because I bet that he's pretty cool to have lunch with. Yeah, that guy, this is what he said about them. Listen to Judge Anderson. He said that their case relied on, quote, the barest legal conclusions without any well-pleaded factual allegations that calls into question the adequacy of Triller's compliance with its pre-suit investigation obligations under FRCP 11. Which is all of the judge shade. This is like legal anger. This is all of the judge shade. And it's just brilliant because this judge smacked them so hard without any well-pleaded factual allegations. It's like the most minimal basis for filing a federal complaint. And the judge was like, but what you didn't do is come with facts. And what the judge can't say, that I'm sure that Judge Anderson in his soul wanted to say, is what you've brought me is fuckery. And I'm not doing this today. Yeet. And he did. He dismissed them. And they are still going round and round in Judge Anderson's court with regard to that and just one remaining defendant. Triller's sack. Triller's sweaty sack. It's been a day. Triller's sack. I am a child and I apologize. This is why we love being here. Triller's sack merely confirms Judge Anderson's suspicions. Triller's sack, do you think they did this on purpose? I want them to have done this on purpose. I mean, I know that the lawyers didn't want to type out second amended complaint the entire time, but do you think they were also amused? Like, I hope that they were amused that they got to just dog Triller's sack the entirety of the motion to dismiss. I hope that someone was as tickled about this as I am, because Triller's sack has pissed everyone off. Triller's sack centers around TEI's use of an excerpt of the broadcast for purposes of commentary and criticism, that it was, in a YouTube video entitled Jake Paul Fight Was a Disaster, the H3 podcast, number 244, which is still up on their channel. And I encourage you all to go watch and see exactly what fair use looks like, because what fair use looks like is using a clip and saying, hey, that sucked. Does it look like he took a dive? We don't like that fight at all. That was terrible. Oh, that was like 10 seconds of terrible in a like super long podcast. But go watch. I'm sure there's timestamps in here somewhere and we'll get to them. Make a note. Afterwards, let's see. TEI uploaded an excerpt of the broadcast onto YouTube as an unlisted video. They used a clip of the fight as unlisted. And that's what they used to play the video that they commented on. And that's part of what they are arguing about here, is that unlisted clip is a problem. Triller's sack alleges that defendants' conduct constitutes 1, copyright infringement, 2, vicarious copyright infringement, 3, violation of the Federal Communications Act. Additionally, Triller seeks to hold Teddy Fresh, Ethan and Hila liable by alleging TEI is their alter ego. Anyone who watches the 42221 podcast can instantly recognize the true purpose of Triller's sack: retaliation against the 42221 podcast because it excoriated the broadcast and its main event. They were mean. In other words, Triller's sack is a brazen and unabashed attempt to intimidate, punish, and silence lawful and protected criticism. This is emphasized by Triller's parent company, Triller LLC, also suing defendants for tortious interference after the H3 podcast criticized and commented on the present lawsuit. It's like, oh, we talked about you. Cool. We're going to sue you a fucking again to try to make you shut the fuck up. That doesn't seem to work with Ethan. Like, it, because the last time that happened, he won. So think that that's going to work. So yeah, that's not going to work. That's not going to work. Also suing defendants for tortious interference after the H3 podcast criticized and commented on the present lawsuit, Triller and its parent company and its owner, Ryan Kavanaugh. This is not the first time Ethan and Hila have been the victims of an abusive lawsuit that seeks to punish and silence their lawful criticism. Rather, both lawsuits are hauntingly reminiscent of Ethan and Hila's prior lawsuit entitled, God damn it, I hate trying to pronounce this name because I'm so bad at it. It's the Matt Haas lawsuit. Hassan Zeta. Please let that be right. The Matt Haas lawsuit, Haas versus Klein. In that case, I have a video on the channel of that case if you're interested in it, where I break down the court's ruling, where the court is like, yeah, what you did was fair use and we're cool. Matt Haas, stop complaining, you lose. Ethan and Hila used 60% of another YouTuber's video for the purposes of commentary and criticism that constituted fair use. The court found that their criticism and commentary of the plaintiff's lawsuit was completely lawful. This case stands on firmer ground than the Haas lawsuit. What they're saying is that this case is better situated to be fair use because of the facts in this case. And they go on to say, because on 422, the podcast used only 0.3% of the broadcast to criticize and comment on it. So if 60% is fair use, then 0.3% sure the fuck is fair use. Triller's remaining claims are defective as well, not only because they are compromised of threadbare recitals and legal conclusions, but because their sack unequivocally sucks. Unequivocally demonstrates how those claims fail as a matter of law. So within the body of the sack, it fails. And that's what a 12b6 motion is for. Look, under 12b6, what you've said, if everything you've said is true, it still isn't a lawsuit. You still don't win. Yeet yourself and we will win. Thank you. Goodbye. We don't want to waste anybody's time. The sack and the procedural background, the allegations of the sack. The sack is not a paragon of clarity. That's kind. The sack is worse than not a paragon of clarity. The sack is terribly fucking written. It had no dates at the beginning. Like, what? The sack is not a paragon of clarity, but the following can be discerned from its allegations. Yeah, if you squint and turn it sideways, maybe you can find what they're alleging. Triller alleges that it's the owner of the copyright in the broadcast. It's the only part of the complaint that I agree with. I think Triller probably owns the broadcast that they put on. I'm good with that part. We're going to go with they own the broadcast for purposes here, which was published on April 17th, 2021. Triller further alleges that it transmitted the broadcast through authorized third parties via online platforms. They streamed it. Triller alleges that defendants' wrongful conduct was 1, watching a pirated or bootlegged version of the broadcast. Yeah, but they didn't plead that, but they kind of alleged it, but it's not a cause of action, because if it was a cause, look, if Ethan was being sued for watching a bootlegged version, the damages would be the cost of the fight, which was what, $50? Okay, Triller, here's your $50. Bye-bye. But that's not what they're alleging, truly. 2, uploading the reference video to an unlisted video on YouTube. 3, showing the URL of the reference video. And then it gets into the deeply legal things. Triller alleges that defendants profited from their purported wrong conduct because H3 is part of the YouTube partner program. They have sponsorships and they sell merchandise. So they're monetizing the re-upload is what they're alleging. So let's see. Triller attempts to plead 3 claims for relief: copyright infringement for the using of the fight, vicarious copyright infringement, and violation of the FCA. The incorporated by reference document and judicial notice. The broadcast is a 4-hour-long audiovisual work. The broadcast being the fight, 6 boxing matches, 2 musical performances by prominent musicians such as the Black Keys, Diplo, Doja Cat, Justin Bieber, Major Lazer, Swati, Snoop Dogg, Ice Cube, Too Short, and E40. That's a lot of musical performances. 3 interviews of boxers by comedian and Saturday Night Live star Pete Davidson. Is Pete Davidson a Saturday Night Live star? I thought he was a musician. What is happening to the world? Either way. On April 18th, 2021, the reference video was uploaded to YouTube as an unlisted video to the SAC, the SoundLad YouTube channel. as defined by Google, and then they define unlisted. I don't need to define. Y'all know what unlisted is. On April 22nd, the over 2-hour-long podcast was uploaded to YouTube. SAC, and then it shows where the references are. Nearly 3/4 into the 422 podcast, the cast of the H3 podcast began commenting and critiquing the fight on the broadcast, including its participant, for approximately 12 minutes. Oh, there's the timestamps. So if you want to go watch, an hour and 25 minutes and 58 seconds to an hour and 37 minutes and 32 seconds. In the middle of the cast commentary and critique, the 422 podcast played 42 seconds of the reference video, which was comprised of 5 seconds exclusively of audio, 9 seconds of both audio and video, and 28 seconds of exclusively video. So they're saying it is a teeny little part of the larger fight used in a very small part in the longer video. So the fight was long. They only used 42 seconds of it. And the podcast was, hours long, and they only talked about it for 12 minutes. So it's not the heart of the podcast. It's not the heart of the video. It's clearly fair use. And it's clearly, used for commentary, right? And criticism. The 422 podcast never zoomed in on the URL in the reference video, so people couldn't go rewatch it. And they go through people not being able to rewatch it. The relevant procedural history. Here we go. This is the fun time. If this is Triller's 5th attempt to properly draft a complaint against the defendants concerning the broadcast. On April 23rd, Triller filed the initial complaint against Film Daily. On April 28th, Judge Anderson issued an order to show cause sua sponte. Remember, that means on their own, regarding why the majority of defendants in the Film Daily action should not be dismissed for improper joinder. On April 29th, Triller filed an amended complaint in that case. The sole additions were adding the H3 podcast and H3 Productions. On May 5th, Triller responded to the order to show cause. On May 6th, Judge Anderson dismissed all the defendants and was like, yeet everyone, you all are the worst. Goodbye. Judge Anderson publicly chastised Triller. Oh, they're gonna get at it again. I love this. Publicly chastised Triller for relying on the barest legal conclusions without any well-pleaded factual allegations, which he noted calls into question the adequacy of Triller's compliance. You didn't do your fucking job, Triller. The adequacy of Triller's compliance with its pre-suit investigation obligations under FRCP 11. You don't have grounds. You didn't plead grounds. Stop it and do your job. On May 10th, Triller filed the initial complaint against the H3 podcast. In this action, its 3rd attempt to draft a complaint against defendants, except it just cut and paste the other one. On May 21st, Triller filed its first amended complaint in the present action, the FAC. Its 4th attempt. And in one of those, Triller pled the name of its own company wrong and had to fix it. Like, just so we know where we're at. Every version of Triller's complaints were merely cut and paste rehashes of the initial complaint. Yep. The sole additions in the FAC were naming TEI as a defendant, including Ethan and Hila as defendants based on their alter ego, comprised of threadbare recitals, and identifying without describing the reference video. Yeah, they added like a date. They said, oh, by the way, it was this video. Because before they're just like a video on a day on this channel. On June 29th, TEI, Ethan, and Hila sent a detailed meet and confer letter to Triller. Hey, Triller. Your shit's flipped. What's not going to happen is that you're going to win this. Can we just meet and confer and figure this out so we can just like literally stop the madness? That's what the meet and confer letter is. Hi. You sure you want to do this? This is why we're going to win. Okay, go ahead and spend your client's money, but it spends my client's money too, and that sucks. But we'll win lawyers' fees at the end of it, so, you do you. On July 12th, 2021, Triller submitted a proposed SAC, the SAC, its 5th attempt to draft a complaint against defendants. The proposed SAC contained nominal additional allegations. Oh, it was a wee SAC. It was a little thing with just nominal changes. Dropped 3 claims and added Teddy Fresh as a defendant. So they looked at the the meet and confer letter and went, yeah, we're going to drop those 3 claims. But what we're going to do is add a clothing company that has nothing to do with the podcast. And we're going to say that it's their fault. I'd love to know what went on behind that decision making. On July 14th, counsel for the parties met and conferred telephonically about the defects in the FAQ and the proposed SAC. Triller was unpersuaded. Triller didn't listen by defendants' arguments regarding the fatal defects of the proposed SAC. To avoid burdening this court with an anti-SLAPP motion and addressing the claims that Triller effectively conceded lacked merit, defendants stipulated to the filing of the SAC. They're like, go ahead and bring the SAC because we're going to say SAC a million times. SAC. Which this court then granted. On July 19th, 2021, Triller's parent company filed an action against defendants in LA Superior Court alleging tortious interference with claims entitled Triller LLC versus TED Entertainment. This action targeted statements made by various H3 podcasts criticizing Triller, its parent company, and its majority owner, Ryan Kavanaugh. Defendants shall respond with an anti-SLAPP motion on September 8th. They did. It's glorious. We're doing that next. The legal standard gets into the fact that you actually have to plead like facts that have like evidentiary support and shit, and that they didn't. And Judge Anderson pointed out that they didn't, and therefore you can't do that. The Ninth Circuit has repeatedly held that on a motion to dismiss, the court can review unattached evidence on which the complaint necessarily relies if the complaint refers to the document is central to the plaintiff's claim, and no party questions the authority of or the authenticity. So they're like, Your Honor, go watch the video. Go watch the video. Go watch the video. Their complaint relies on the video. The Ninth Circuit says you can. Go watch the video. We've timestamped it. You know where it is. Go watch it. They then get to the copyright infringement and vicarious copyright infringement. What they put on the internet was fair use. Where they got the video from is not as much of a concern because other places aired clips of the fight too. Here, the SAC concedes that the broadcast reference video and podcast were transmitted, explicitly alleges that defendants did not simultaneously fix the broadcast with its transmission, and then they get into deep nerd copyright law and did a fantastic job breaking down why the digital streaming is not the problem and why it is not a fixed work, and why this is not a copy of the work. It's not even a restream of the work. It's commentary of the work. And they did the legwork on why this is not copyright infringement, but is also fair use, and did a really excellent job with it. So this, oh, good. My computer froze. Sweet. So they go through kind of the doctrines of copyright infringement, fair use, the fair use factors. If you want to know more about the fair use factors, I get all the way into them in the Matt Haas case because the judge lays out each factor and all of the parts of that case that go into them. But in general, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as the whole, the effect of the use upon the potential market or value for the copyrighted works. And again, the value in the fight is the day of the fight. They're going to argue that you can sell restreams, but this fight was already out there, and the criticism days later isn't going to diminish that value. They go through the different intermediate use doctrine and others. Again, they really went into the law of this, and I thought did a very good job getting into the law of this. We are not getting, look, we'll be here for 3 hours if we do a whole class on copyright, but I think, again, that they did a great job talking about the fact that the copy was made for fair use. This was used for fair use. This falls under the fair use doctrine. It's a raw material, et cetera, et cetera. Then they go back and quote the Haas case. So all of Ethan Klein's fighting in the Matt Haas case and the likely hundreds of thousands of dollars, or at least $100,000 that was spent to fight the fair use case, paid off because now his lawyers get to quote the case law that he and his lawyers created. And it's like, we've already been to this rodeo. Here's a picture of us at the rodeo. Listen to what that judge said about the rodeo. And that applies here because we've already done this before. because the Haas case did create a very good breakdown of fair use in the YouTube context for commentary. So whatever you think of Ethan Klein, going after that case, he did a service to the YouTube community by fighting that case. And again, not to bring up mortal enemies in the same sentence, but think of what you will as of Keemstar, but his anti-slap motion against Romeo Lacoste did the same thing. It was, we're not going to do this. And YouTubers fighting up and saying, we're not going to allow you to just try to intimidate us with regard to lawsuits, sets good precedent for other YouTubers to know when it's fair use, it's fair use. When it's not, it's not. And Ethan Klein is getting to rely on the work and the money and the likely stress that it caused to fight the Haas case, because their lawyers cited it over and over and over again, because the Haas decision is a great decision for fair use. And I have a whole video breaking that one down. And I was just like, oh, I see you quoting the Haas case. The Haas case is a New York case. I'm sure Triller will argue, if they think of it, that, you know, well, this court doesn't have to follow that court's case law because that's a New York case. But again, it's a federal New York case. This is a federal case here. So I think it is instructive and illustrative. And fuck, if I had a client who had gone to this length to get a ruling in their favor, I would absolutely quote the shit out of it. They go on and say, it is well established that among the best recognized justifications for copying another's work is to provide comment on it or criticism of it. The Haas case, quoting other cases. Then they talk about transformative works. They talk about the strong presumption that favors, there is a strong presumption that factor one favors the defendant if the alleged infringing work fits the description of uses described in section 107, including criticism and commentary. Again, if you're like, Emily, blah, 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 yes, we're into the law part, not so much the T part. They go on to say, in the Haas case, the court found that Ethan and Hila's use of a YouTuber's video was quintessential criticism and comment, irrespective of whether one finds it necessary, accurate, or well executed. This case is no different. If you do not like the commentary or criticism, it doesn't matter. It doesn't matter if you don't like it. It's still criticism. And then they go in, and then the lawyers get to go into what the criticism is. It's like, let us tell you how much we criticized. When showing excerpts of the video, the cast of the 42221 podcast critiqued Ben Askren's physical fitness, including his ability to box and how he was knocked out by Jake Paul. They critiqued the fight itself, including the mismatch between Paul and Askren, the fight's brevity, and the referee's decision to call the fight for Jake Paul, and whether one of the divers, quote, took a dive. The commentary and criticism surrounding the podcast use further emphasized the transformative use of the podcast. They go through all of the podcast and what criticism was used, and then continue with, we're so deep into the legal of this, we're gonna scoop because we have to get to the anti-slap, because these all go to the fair. This is only the second fair use factor, and we are only 26 pages of 200 in this. Mods are like, God, Emily, not 200 pages. No, they include so much of the underlying cases and stuff. This is not 200 pages of motion. It includes the judge's ruling and all that stuff too. So we are getting to the fourth factor of fair use. Again, I think all the fair use factors play into this, but this is a motion to dismiss, so it needs to be tremendously detailed. It is very detailed. There is quite a lot of law in this that supports the fair use of this case. The FCA claim, Triller's FCA claim fails because it relies solely on legal conclusions and threadbare recitals to allege defendants unlawfully intercepted the broadcast. There is literally no proof that Ethan or the H3 podcast or any of their companies hacked into the wires and intercepted the broadcast and rebroadcast it. What? So again, I think that'll probably get yeeted because they didn't. There's no, or at least if they did, they didn't plead it in any way to show that they did. They go through the alter ego allegations. The alter ego allegations are saying that somehow Teddy Fresh is responsible for what's on the H3 podcast, and go through why those fail and why they are not alter egos, and why the company, the production company, is really the only proper defendant, not Teddy Fresh, not Ethan and Hila as individuals, but just the company, because that's the company that produces the podcast. Conclusion. Triller's abuse of the judicial process to punish and silence lawful speech can no longer be countenanced. Triller's lawsuit is retribution for the 42221 podcast lambasting the broadcast as a disaster. Ironically, despite Judge Anderson's public chastisement and Triller's numerous opportunities to file a well-pleaded complaint, Triller persists in filing, quote, disastrous and fatally defective complaints, and the SAC is no exception. The SAC is disastrous and defective. Since Triller consistently refuses to cease its abuse of the judicial process and defendants, it is up to this court to make Triller stop. Your Honor, make it go away. Make it stop. Therefore, for the reasons stated above, defendants respectfully request that this court grant its motion to dismiss the SAC with prejudice. Dismiss the SAC with prejudice so they can't refile the SAC. None of the SACs, all of the SAC. Terrible. It's terrible. Thank you, Your Honor, for getting rid of this SAC. And then they have the request for judicial notice with regard to all of the exhibits that are attached. They are thorough. They are extensive. I mean, so much. They also get into a declaration of Ethan, which really goes through this is a true and accurate representation of the podcast. This is a true and accurate video. This is how the reference video has worked, and most of what's put above with links so that the court can go through and watch it. They also put the lawyer's declaration in. Hey, Your Honor, this is the law from the Film Daily case. And then they added all of the Film Daily's stuff into here, which is great. This is Judge Anderson's scathing reference and order to show cause. We went through those on the channel if you want to go watch those. I thought they were great. We have to get to this anti-slap because there was so much left. There are still almost 5,000 of you in here. Thank you so much. Don't forget to do the YouTubey things, the likey and subscribey things. We're sorry. We're putting the SAC aside for a moment. We need a break from the SAC. The SAC is exhausting, and we are going to get into the world of anti-slap, which we've previously talked about. So we talked about this lawsuit. It's basically the one that alleges that Ethan, Hila, and everybody are responsible for what's said in a subreddit because Ryan Kavanaugh's feelings seem to be hurt. So here we are with the anti-slap saying that lawsuit is nothing more than a strategic litigation against public participation. What you're allowed to do on the internet is to criticize others. Now, sometimes that criticism goes too far. Sometimes people go real life with people, but guess what? It's not. Often it's not defamation. You can be mean to people. You can call people names. You can say that this person looks like that person. You're allowed to make comment and criticism on the internet. It's the internet. What you can't do is say shit that's not true as if it's true. All right. Introduction. Free speech for me, but not for thee. This is the theme of the relentless campaign by plaintiff Triller and its majority owner Ryan Kavanaugh to harass, punish, and silence defendants for exercising their First Amendment rights. Triller and Kavanaugh have repeatedly abused the judicial system to silence commentary and criticism made about them on the H3 podcast. This assault on defendants' lawful criticism began by Triller and Kavanaugh causing Triller Fight Club to sue defendants for copyright infringement because the H3 podcast used a short clip of the Jake Paul, Ben Askren fight for commentary and criticism. Triller and Kavanaugh are now suing defendants for their lawful speech criticizing the copyright action. Yeah, your lawsuit sucked. It's flipped. We hate it. Then for criticizing Triller, then for criticizing Triller's social media app, and then for criticizing Kavanaugh themselves. You know who's not suing? Kavanaugh. Kavanaugh's not suing. Triller Inc. is suing. A company can't sue because one of its owners' feelings are hurt. We'll get there. Don't worry. We'll get there. Kavanaugh's not suing. The company's suing. The first amendment complaint, we're at the FAC, is both confused and confusing. It's chock full of irrelevant allegations and Rube Goldberg-like legal theories devoid of merit to disguise its direct assault on speech protected by the First Amendment and statutes intended to promote the same. Fortunately, California's Code of Civil Procedure, the CCP, Section 425.16, empowers this court to prevent Triller and Kavanaugh's attempt to improperly use the judicial system to harass, punish, and silence defendants. This is why they are bringing a anti-slap motion. Prong 1. Triller's causes of actions arise from protected activity as defined in the anti-slap statute, protected activity being First Amendment activity. The matters are of widespread public interest. The use is First Amendment, therefore it's protected. Prong 2, Triller can't demonstrate it has a probability of prevailing on any of the causes of action. First, because the fact alleges that H3 incited its viewers by asking them to download the Triller app and leave an honest review. Guess what that is? First Amendment protected free speech. You guys try it yourself. You see what you think. Go ahead. Under the First Amendment, incitement is actionable only when the advocacy is intended to and directed to creating imminent lawless action. There's lawlessness up in these Apple download app reviews. No. Negative ghostwriter. The pattern is full. Second, Triller's causes of actions are defamation claims in disguise, right? Because they never actually plead defamation. Predicated on Triller's allegations that the H3 podcast made false, misleading, and malicious statements. As such, Triller must overcome the First Amendment protections for defamation law, which it cannot do. Each statement identified in the fact are true, unprotected opinion, or not of and concerning Triller. Fred, seriously, man? Do you feel better now that you've yeeted it off the desk? We're good? Okay, now we're good. Fred had to throw that pen off the desk. He was very annoyed with it. Okay, I'm glad we're better now. Sorry, back from our pondered break. Each statement identified not of and concerning Triller, those are the statements about Kavanaugh, and is not made with actual malice, because again, public interest. Third, Triller seeks to impute third-party statements from the H3 subreddit. Kat, you were standing on my keyboard. What did you do? I know we've reached the very end, but now I can't see my screen because you've turned the brightness all the way down, and I don't know what you stepped on to do it. Darn it, Fred. How did you turn down the brightness? Oh, wait. Where's the turn back up the brightness? Oh, there it is. We found it. All right, buddy. The Pawnard is done for the night, and he's like, yeah, we're just done. All right, let's fix this now that we've stepped on the keyboard. All right. Triller seeks to impute third-party statements from the H3 subreddit onto defendants because they are moderators of the H3 subreddit. Section 230 says, no, you can't. Finally, Triller fails to properly plead. It'd be like trying to sue YouTube for what people on YouTube say. You can't. Section 230 does not just protect YouTube and Facebook. It protects publishers of information. Things on subreddit are protected. So let's get back into it. I know everybody's very happy to see you. You're all good. You can just stay right there. Defendants, we know who the defendants are. Triller and Kavanaugh. Triller owns the Triller app and is the parent company of Triller Fight Club, which is suing. They have an app. They have a lot of downloads. They have over 160,000 reviews, proving that the foot soldier reviews are a problem is going to be very interesting. Kavanaugh is the majority owner of Triller. Kavanaugh was formerly CEO of Relativity Media. At Relativity, they are alleging Kavanaugh drove the company into bankruptcy twice. During Kavanaugh's tenure, Relativity was reduced to a mere $30 million in assets. Somebody reduced me to a mere $30 million in assets. I'll take it. Relativity was reduced to a mere $30 million in assets and with nearly $600 million in liabilities. Nope, don't want any of that. That's not good at all. Despite Relativity's insolvency, Kavanaugh made Relativity pay him $2.5 million consultant fees. In arbitration, the Honorable Terry Friedman found that Kavanaugh fabricated, fabricated a memo alleging sexual harassment against the former president of Relativity, Adam Fields. In that same arbitration, Kavanaugh falsely testified under oath that the memo was authored by a former in-house counsel at Relativity. Don't say the lawyers did it. That's not going to go well. In retaliation for exposing his false testimony, Kavanaugh sued Mr. Fields. Good, so there's other stuff. And I think Relativity, I think, and Kavanaugh are involved in the movie that was released without the likeness rights being released. We talked about it. I'll have to look it up so we can talk about it again, because the Inception, 6 degrees. Oh, you just want to play with this? Okay, go ahead. Fred's like, Mom, we're supposed to be done streaming. Fred and the mods are like, but it's 2 hours. It's 2 hours. Kavanaugh has been embroiled in several other public controversies. This is going by way of A, Kavanaugh keeps fucking with them, so they're going to put it in the complaint, but also B, look, what we said is not defamatory, so there's no tortious interference of anything, because what we said is true. For example, Kavanaugh's nanny was forced to sue him when he refused to pay her, they say. It goes on to say Kavanaugh's former business partner, Elon Spar, called Kavanaugh's new business venture, Proxima Media, a Ponzi scheme. Kavanaugh has been arrested twice and convicted once for driving under the influence. These controversies have caused Hollywood to shun Kavanaugh. Okay. The copyright infringement lawsuit, we just talked about it. We don't need to go into it. It's for this judge. Then they get into the podcasts at issue here. On June 11th, 2021, the H3 podcast episode discussed Kavanaugh being behind the copyright action. A Variety magazine article that reported that Spar accused Kavanaugh of running a Ponzi scheme, whether Kavanaugh physically resembled Harvey Weinstein. On July 1st, the podcast discussed the same topics. And Ethan tried the Triller app and gave it a 1-star review. On July 2nd, on the H3 podcast, they discussed the same topics as above, that Triller misrepresented Kevin Hart's presence on the Triller app. It's like 6 degrees of Kevin Hart. And that the contents of Ethan's review of the Triller app, which are in the lawsuit, if you didn't watch that video, it's highly amusing. A video of Noah Beck, a prominent social media influencer, in which Mr. Beck stated that the Triller app was flipped because the camera function was inverted. It's flipped. It's flipped. The Triller app, and then they discussed the Triller app and how viewers should download it and provide an honest review of it. July 8th, H3 podcast discussed the same topics as above, chastised troll reviews of the app, instructed viewers not to give troll reviews of the app, but give them an honest review. The present lawsuit. God, if you step on it, it makes it smaller. I know. I hear. Look, stop stepping on my keyboard. I can't keep my place if you keep stepping on the keyboard, my darling. Okay. Defendants counsel and Triller's counsel, who also represent Triller and Kavanaugh, agreed to meet and confer on July 14th to discuss why the copyright action failed as a matter of law. On July 13th, however, Kavanaugh sent defendants a demand for retraction, the 713 letter, which failed to identify a single alleged defamatory statement in the 611 podcast, the 71 podcast, the 72 podcast, or the 78 podcast, collectively the podcast. Approximately 30 minutes before the parties were to meet and confer on July 14th, Triller sent defendants an initial version of the fact in the present action. Triller's counsel sought to hijack the meet and confer to discuss Kavanaugh's threatened defamation lawsuit and the present action. Defendants' counsel insisted on discussing the deficiencies of the copyright action. So it sounds like when they were supposed to meet and confer about the other lawsuit, the copyright lawsuit, that the lawyers were like, no, but we're going to sue you here too. Let's talk about that. And they were like, no. We're going to talk about this. Do not try to talk about the new thing. We have to meet and confer on the other thing. There are rules, people. There are rules. Fred, there are rules. Anyway, so the meet and confer, it sounds like went great. Love to be a fly on the wall of that meet and confer. They go through the legal standard with regard to the anti-slap. Defendants must establish that the challenge claim arises from protected activities. Is this actually First Amendment speech? And then if the court goes, yes, this is First Amendment speech, then the plaintiff has to prove the probability of success. If the plaintiff doesn't prove the probability of success, the entire action gets dismissed with prejudice. You can't bring it again. And then the losing party, the person who sued, has to pay the defendant's legal fees. The anti-SLAPP statute is to be construed broadly and is designed to encourage participation in matters of public interest by targeting lawsuits brought primarily to chill the valid exercise of the constitutional right of free speech. That's legal speak for lawsuits to force someone to shut the fuck up are disfavored because what you're allowed to do is talk about things of public interest and public matters. They go through the different prongs. They talk about the way that the speech was First Amendment speech, that the claims arise out of First Amendment speech, that the activity is public, and that it's well established that YouTube videos are covered by the anti-SLAPP statute, just being like, just because it's on YouTube doesn't make it different. They talk about the fact that Kavanaugh is an individual of public interest, that Kavanaugh has been the subject of countless media reports, including on his personal life, misdeeds, mismanagement, and majority ownership of Triller, and that Kavanaugh is a person in the public eye and a matter of widespread public interest. So they say that the defendants have met their burden because it's protected speech about a matter of public interest. Prong 2, Triller cannot show a probability of prevailing on the merits. If you keep rubbing on my mic, you're going to keep bumping my mic. I don't know how loud that is for everyone. You can just chill there. That's fine. Under prong 2, Triller bears the burden of proof to establish that there is probability that it will prevail on the claims. You could just stay here. That's fine. Say hi. Nope. And then demonstrate that the complaint is both legally sufficient and supported by a sufficient prima facie showing of facts. This doesn't even go to discovery. It's just like, as a matter of law, can this sustain? No, it can't. No, it can't. Triller's claims fail because it cannot plead or prove incitement. The First Amendment protects parody, rhetorical hyperbole, and loose figurative or hyperbolic language. And this goes to the App Store reviews. The First Amended complaint says that what Ethan said was, yeah, people should judge for themselves. Go download the app, leave a review. Give Triller 1 or more stars, some amount of stars between 1 star and 5 stars, and do not leave troll reviews. So on the language of the First Amendment complaint, it says, oh, what have you found? Here, go ahead. Go ahead. I tossed it. You can play with it. On the First Amendment complaint itself, it says that what Ethan said was, go give it some amount of stars, download it, try it, rate it. So yeah, fine. Therefore, Triller could not show a probability of prevailing because even the way it's pled, you can't show a probability of prevailing. Triller's claims fail because it cannot meet the constitutional requirements for defamation. Triller's causes of action are defamation claims in disguise because the causes of action are based on false, misleading, and malicious statements. Triller is, and Mr. Kavanaugh runs, a Ponzi scheme. The statement fails to meet the First Amendment requirements for defamation. The statement was never said in the podcasts. Okay, well, it has to be said somewhere. The podcast accurately discussed the accusations Spar made in a verified complaint against Kavanaugh. So his business partner said he did this. Okay, that's reporting. Further, the statement is not of and concerning Triller, but it's a statement of and concerning Kavanaugh and Proxima Media. So Triller can't sue for statements about, Kavanaugh. Then it goes on to talk about the next statement. Triller falsely represented that comedian Kevin Hart uses the app. Not Kevin Hart. The statement is true because when the podcast aired, Triller's description for the Triller app stated that millions have made Triller videos along with huge global stars such as Kevin Hart, despite Hart having no presence on the app at the time the podcast were made and aired. Indeed, Triller effectively concedes this point by removing Hart's name from the Triller app description in the App Store. That the app is flipped. The statement's Mr. Beck's statement. Yo, Triller, my thing is flipped. The sack is flipped. The fact is flipped. The app is flipped. It's all fucking flipped. It's flipped. He said it, not us, therefore it can't be defamatory. They say the phrase is non-actionable because it's opinion. It's Mr. Beck's opinion, and they're just reporting on it. Mr. Kavanaugh bears a physical resemblance to Harvey Weinstein. If beauty is in the eye of the beholder, the same holds true for the lack thereof. Spicy. 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 They're just, okay. This statement constitutes opinion because it expresses the subjective perception that Kavanaugh looks like Weinstein. Further, this statement is of and concerning Kavanaugh, not Triller. Accurate. Kavanaugh sued defendants, not defamation. Fact. The statement is substantially true. Triller's counsel told defendants counsel that Kavanaugh was behind the copyright action in the present action. Further illustrating Kavanaugh's involvement are 1, the facts, numerous allegations of false, misleading, and malicious statements regarding Kavanaugh. 2, Triller's counsel sending Kavanaugh's retraction letter. And 3, that Kavanaugh's the majority owner of Triller. So yeah, fair. Triller's claims are barred under Section 230. You can't sue Ethan's company for what a subreddit says. That's not how that works. Section 230 states no provider or user of an interactive computer service shall be treated as the publisher or speaker. You cannot treat Ethan as the speaker for what people say on Reddit. It's the same way you can't sue Facebook for the stupid shit people say on Facebook, or you can't sue Twitter for Nicki Minaj's cousin's balls. Like, you just can't sue people for what a user says. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. The content provider being the Reddit users. The plain language of Section 230 applies to users of a website like Reddit, including individuals. Courts have consistently held that 230 confers users of websites broad immunity from tort claims. Accurate. Why other than because I appreciated the giggle? Because look, going over the lawsuit with all of the pictures of Reddit did give me a giggle. It made me laugh. I found it to be highly amusing, but you can't hold someone responsible for shit they didn't say. It's not how that works. Okay. Here, Triller seeks to impute statements made by third-party users of a subreddit onto defendants because they are the moderators. Therefore, Triller cannot show a probability of prevailing because Section 230 bars it. Triller fails to properly plead and cannot prove any claims. And then they go through the claims with regard to intentional interference with contractual relations. Aside from impermissible legal conclusions, Triller fails to properly plead facts demonstrating 1, a contractual relationship between Triller and a third party, 2, defendant's knowledge of said contracts, 3, any intentional acts by defendant designed to induce a breach or disruption of the contracts, and 3, any actual or breach or disruption of a contract. And then there's a footnote. Let's read the sassy footnote about intentional interference with contractual relationship, shall we? Yes. Footnote voice. Triller labels this claim as intentional interference with existing economic relationship. No such claim exists under California law. Rather, it appears Triller is alleging intentional interference with contractual relationships, which requires Triller to plead and prove 1, a valid contract between plaintiff and a third party, 2, defendant's knowledge of a contract, 3, defendant's intentional acts designed to induce a breach or disruption of a contractual relationship, 4, actual breach or disruption of the contractual relationship, and 5, resulting damages. Triller seeks to bring a claim for intentional interference with existing economic relationships, but that's not a claim. And when I read it, I was like, maybe they changed the language because the laws update, and it's not something that I am alleging people of doing. But I'm glad that the lawyers have said, no, It's an intentional interference with contractual relations. They pled it wrong. I'm not crazy. I appreciate the validation. Isn't that what all of us YouTubers so desperately need? Just a little validation. But yeah, they didn't plead any of that, and that cause is not going to be sustaining anything. The second claim for intentional interference with prospective economic relationships is again not pled. The third claim, negligent interference with existing contractual relationships. Same thing. I made a shock face. Because here's the thing. No such cause of action exists. So not only did they plead one wrong, but they pled one that just isn't a thing. In California, there exists no cause of action for negligent interference with contractual relationships, while there exists a cause of action for negligent interference with prospective economic advantage. They are different. The California Supreme Court has rejected the cause of action for negligent interference with contract. Therefore, Triller has no probability of prevailing on this cause of action. Yep, it doesn't. It's not a thing. It's not a thing. You just can't do that at all. Triller's fourth claim fails. Negligent interference with prospective economic damage. The elements are the same for intentional interference with prospective economic damage. They didn't plead it. You can't prove it. I don't know. They didn't prove any interference with any economic anything. They didn't prove that Ethan did something like to cause an interference with a contractual relationship. In other cases, what we've seen is, hey, somebody reached out to a sponsor and said, look, you shouldn't work with that person. Well, okay, that is a direct interference when there's a known contractual relationship. That could fly down the road, but not in this case. That's not been pled or shown. So I think they have a good basis on their anti-SLAPP motion. And I think it's going to be hard for Triller to overcome this motion. Conclusion. Triller and Kavanaugh's assault on defendants' First Amendment rights must end. Triller and Kavanaugh have profited handsomely from the First Amendment. It is time they learn it does not benefit just them. For the reasons stated above, the court should strike Triller's meritless your face, and award defendants their mandatory fees and costs that will be the subject of a separately filed motion, which is, hey, you can't win, strike this, pay us, goodbye, we're done. And then they attach the legal stuff, and that is the end. Friday night's not always this long, but it's a good anti-SLAPP motion that makes all of the points, because the lawsuit is a piece of shit. And I don't normally have such strong language for any lawsuit other than the Triller suits, because they are not well-pled suits. What are we doing? What are we doing? What did we find? Fred's like, what did we find? Oh, mom, don't. Here, we'll put it there. So he's having a very good time with whatever he has found. The lawsuit is just not a good lawsuit. It is a temper tantrum in legal form because some people said mean shit on a subreddit. Guess what? If you are a high profile CEO, people are going to say mean shit about you. It's not actionable in most circumstances. Ugh. So it'll be interesting to see. The thing is, here's the thing that's hard about this, and we're not going to have a ton of time for questions, and I apologize for that. I will try my best to get to some of the super chats I missed. Here's the thing. Even though H3 stands to win both of these motions, and if they don't, I will be surprised. More surprised if they don't win the anti-SLAPP than on the motion to dismiss. It'll be interesting to see what the judge does, because that's not a well-pleaded complaint either. But on motions to dismiss, the judge can say, yeah, you get one more chance to refile it, go for it. And that can be really annoying. But with the anti-SLAPP, that's not a thing. So if the judge rules on it, this gets yeeted, it's done, they get their fees. It still takes energy, time, stress, and money. You still have to pay your lawyers to defend all of this, which is why anti-SLAPP motions exist. So if people with money try to silence others, most that are being kind of slapped can have some recourse early on in the procedures before discovery takes place, which makes it hard for plaintiffs if they don't have the discovery and you're in an anti-SLAPP jurisdiction. You need to have everything before you go to discovery. Otherwise, you might get slapped right out of court. So it's still time and energy intensive. So this is going to be a very interesting case. We're going to watch it play out. I'm keeping an eye on the other lawsuits, but this one in particular, the SLAPP suit, is not well taken by me. The suit sucks. It feels like a temper tantrum on paper, and I don't like it. And other suits I try to give a little bit more leniency to, but yeah, this one's just really bad, and there's no two ways around saying it's really bad. That's my opinion. I don't like it. Most suits I'm like, well, they've got points here, there's defenses here, there's questions here, there's questions there. No, this one sucks and I hate it. That's how I feel about the Triller suits. You guys know that's how I feel about the Triller suits. That's what it is. We need to get Fred his own feed so he can go live. I mean, right now he's just playing with stuff, which is great. Question, what's the status of the original Triller lawsuit with only defendant remaining? The last time I looked, there were motions pending, but I hadn't checked on it. So I'll check on it and I'll update you guys on social media. So if you guys have not followed me on social media, please do, at the Emily D. Baker on Twitter, on Instagram. If you are in North America, you can join the text crew, textemily.com. Fred is under my feet. What are you doing? Here. Everyone just wants to see you. Oh my goodness, your toy. Where? I can't pick it up off the ground. Here. I have it. Go ahead. It's over there. Fred's like, what are we doing? Can I still play? At the Emily D. Baker for the socials. If you're part of the text crew, amazing. And I will update you there. If you are in the Patreon, I will have updates for you guys this weekend. And yeah, Moody Magoo just came in now. My 14-year-old broke his foot while walking down the stairs watching TikTok. Well, that's no good at all, but it does remind all of us not to be watching our phone while we're walking downstairs. Does YouTube know who Mike is? I don't know if YouTube's not compelled to give up that information yet. So I don't think that's going to happen. And Triller has to do their investigation to try to find it. So I don't think that they have. Okay. I know. It's so fun. He has found like a little twist tie for something that is very slidey. So he's super excited. Would the Triller lawyers be better as boxers? I don't know. Maybe that's what it is. If they lose, they have to box one of the Paul brothers. That would be fantastic. Let me see if I can get to a few of the super chats I missed. Thank you. I know this was a long one. We had a lot to cover. I'm sure there is things I missed. I will try to do my best, but the mods have been writing for 2.5 hours. It's a long stream. Wildflower Tea, thank you. Appreciate your breakdown. Thank you, Emily. You're welcome. Have the Paw Nerds tried cat wine? I have no idea what that is, so no, but that sounds amazing. Catnip tip for the Paw Nerds. We definitely need some catnip in the office. But he normally sleeps through most of the stream. At about 2 hours, he's like, I'm done. And why are you not done? So that is facts when it comes to Fred. I'm sorry we didn't get to too many questions. I will do some Q&As over on Patreon. And thank you, Ashley Vincent. I am looking for a few more as we say goodbye. I appreciate it. I'm seeing a lot of comments about our first story from tonight. So let me just go look at social. It sounds like is there stuff happening while I'm live? Yes. Pete Davidson made fun of Jake Paul and he was so mad. I saw clips of that. It was just odd to me that they called him a Saturday Night Live celebrity. I didn't know what they meant by that. It was odd. Let me see. What else? I do not see any, but I see a whole lot of comments. So let me go look at social real quick, because what I'm seeing you guys say is that Gabbie Petitio's fiance is missing, and that's not good. Let's see. Oh, thank you, Tech, for sending me the Twitter link. We're just going to pull that up real quick, because as news is happening as we're talking. Yeah, running's not a good sign for anybody. Breaking: attorney for Brian Landry, who's the fiance of missing social media influencer Gabbie Petitio. Be advised that the whereabouts of Brian are currently unknown. The FBI is currently at the residence removing property to assist in locating. Oh, they're assisting to locate him, as the FBI is now looking for both Gabbie and Brian. Uh that's odd. That's just odd. So I will be absolutely covering that, cuz I don't know if the search would have just been for things to find him, and when did he go missing? And why didn't anyone say that he was missing until they showed up with a search warrant? All of that is very sus. I will absolutely be following it. Because it's just odd. Like, did his parents know he was missing? He's staying with them. His sister gave an interview a few days ago. There's a lot of questions there. So I will absolutely be following that if you guys want to follow that as well. Let me try to get to the most recent comments. It absolutely seems sketch. Twitter claims he's not been around for 3 days. I'm going to absolutely look for reporting, but if he's not been around for 3 days, his parents should have said something because he's staying with them. Question: did he go missing after her, or have they been missing together? Robbie, she did not return. He and the van came back to Florida a week before she was reported missing. His parents called police to tell them he's missing. They're saying went missing Tuesday. That's very, very odd. So we will absolutely be looking into that. I have a lot of questions. It's just very, very interesting. So anyway, in the anti-slap motion, the last thing I was going to say, I should have swooped because we got to questions and we are going to go. Sarah, thank you for the super chat. Foot soldier right here. And this is my first live. You're welcome. Triller sack made me laugh so much. Well, thank you so much. Let's see. Yeah, they didn't attach. I was going to look and see if they attached the letter Kavanaugh sent, but I don't know if Ethan has shared it. Restic said he just went missing. Family called the police and they just announced it. Yeah, I will need to look at the timing of that, because if he's been missing for days and his parents didn't call the police when he's living with them, that's very strange. And if he just went missing when they showed up with a search warrant, that's also strange. So, Fred. So I will definitely be looking into it. Breaking news is always hard because you never know what's going on. Finally catching a live. Been waiting all week. Thank you. You're welcome. We're happy to make your Friday night live, and I will be absolutely covering this more. I don't do a ton of true crime. I don't, because it's kind of hard, but I will absolutely be interested in seeing it. Ethan shared the letter. Perfect. I will go look at that video for it. Y'all, it's been so much. It's been so much today, and we got through all of it in 2.5 hours. A huge thank you to the mods, and a huge thank you for all of you. Thank you for the mods for sharing the super chats that I missed. I'm going to try to get through those real quick. Narco said, sorry, I'm running behind, but did you see the body cam footage of Gabbie and Brian? Police had them separate, came across them having an argument. Now he's missing, confirmed by his attorney. Shaking my head, sad. Yeah, it's a lot of circumstance. I've watched some of the body cam footage, not all. It is difficult to watch. And I know that there was a reading done by Observe on it that I will be watching probably later tonight when I go get in a bath, because that's what I do after I live stream. I know. Well, after I play with you. Of course, after I play with you. Question: did you see the statement that Triller wanted Ethan to read on his podcast? That's the letter we're talking about, the retraction. So I will go look for it, and I will go look for it, because I'm sure Ethan did absolutely share the retraction. Is the Holmes trial being broadcast? I don't know if it is. Law and Crime would probably have it. They did the Durst trial, which actually came back in a verdict, a guilty verdict tonight or this evening, West Coast time. So to everyone who was waiting for a resolution of the Durst case that's been going on and on and on forever, it was resolved. So All right, I'm going to get to a few more of these super chats. Again, thank you for your support. If I miss any, it was a busy night. I'm sorry. Bonnie Edwards, how do you feel about the Durst conviction? It took quite a while and quite a lot of effort on behalf of prosecutors and law enforcement, and it was held in front of one of my favorite judges. So it was nice to see clips of Judge Wyndham on the TV because he is such a tremendous bench officer. I think that the DA's office did a great job. I think Lewin did a great job. Durst was going to be a difficult one. I know there were a lot of people going, this is going to be a hard one to convict on. So it shows that the jury didn't believe a lot of what he was selling. And that's why you go to trial, to let the juries decide the facts. So that's how I feel. Sierra shared that Brian is officially missing. That's why the FBI were at his house. Let's hope he doesn't do something that will stop us ever finding Gabbie. I mean, hopefully not. I imagine the speculation must be hard, but if he doesn't know anything, it's really easy to say to the police, look, I don't know anything. So it's crazy. Did you see last night's episode of Dark Side of the Ring? No, would love to hear your breakdown on the legal stuff. I have not. I don't even know what that is. Be shocked that I don't have a ton of time for TV outside of what we do and family life. It has been a very busy week with kid stuff. So not a ton of time for the TV other than Housewives, because then I get to talk about it with Up and Adam. I streamed a lot this week. And Diane said, you're famous now. I don't know about that. Todd Chrisley mentioned you in his podcast and told people to come watch your channel. Well, hello, everyone who found me from Todd Chrisley. I did get sent lots of clips on that. I saw lots of you clipping out on Twitter. That was very sweet. I know Todd Chrisley is going through his own legal stuff with KJ. And I think that is, he's a fellow Middle Tennessean, which is very nice. And we have, he has reached out and we have chatted briefly. He seems like a very nice man. And it is what it is. It seems like there are lawsuits a brewing on that front. And if and when anything is filed and in public records, we will talk about it too. So for tonight, the mods are like, we have wrapped up 17 times. Yes, we have. I appreciate all of you for being here. They're not all going to be supersized streams. But some of them are. Tuesday's going to be short. Tuesday's going to be shorter because your girl's got stuff to do. But I've got a new podcast coming for you next week that I'm working on with regard to LuLaRich. I've covered their lawsuits some, so it's a look at the kind of newer updates on the lawsuits and talking about my thoughts on the documentary, which I thought was really well done. And next week, we've got a stream on Tuesday, a stream on Friday, and then I've got some traveling again. So next week's the week to catch it. And that is it. You are welcome. Thank you for being here. Follow me on the socials. I will see you soon. Cheers. May your Wi-Fi be strong. May your families be well. May the odds be ever in your favor. And may your toilet paper be plentiful. I appreciate you for being a Leonard. Okay, bye. I'm going to say goodbye. We're saying goodbye.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.